Okay. Good afternoon. In accordance with Sections 45 and 53 of the Planning Act, this meeting of the Committee of Adjustment of the City of Toronto was called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, for permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid, in-person, and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelists when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure you include your name, address, and email address because the committee and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or, in some limited circumstances, to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure. I will call each item in the order listed on the agenda. When making your submissions, where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5 minutes. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Please note, the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then individuals, either in support or opposed to the application, will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. Are there any declarations of interest of panel or staff for any of the items in the afternoon time slots? Yes, Aaron? Which number?
Case number 29, please.
29?
130 Kennedy Avenue.
Okay, and you received a notice, right?
Yes, I do.
Okay. Are there, Madam Deputy Secretary Treasurer, are there any deferral requests for this on this afternoon's list?
Good afternoon, Mr. Chair and panel members. Yes, we do have two items. Item number 19, 50 Nassau Street, file number A0632/23TEY. And then item number 31, 118 Havelock Street, file number A0653/23TEY. That one is scheduled for 3:30 or shortly thereafter.
Right.
And I don't see any files to be closed this afternoon.
Thank you. We now proceed to number 19, 50 Nassau Street. The purpose of the application to construct a new three-story ancillary building with cantilevered second and third stories containing one laneway suite and one parking space on the ground level in the rear yard abutting the laneway. With this application, we have material submitted by the applicant, reports from community planning and transportation services, and 11 form letters in support by occupants of Nassau, Augusta, and Oxford Streets. Nova Tayona.
Yes, that's myself. I am the architect acting as the agent for BALDWIN, the owner of 50 Nassau, and we are requesting a deferral from the committee in order for us to fully take a look at a transition letter that we received just last week ahead of the long weekend. And we weren't able to fully validate the conditions into a revised set of ahead of the long weekend. And we're also taking advice from Simon LaFosse in community planning. So we're working in concert with community planning as well as transportation in order to ideally suffice conditions and their consent.
Okay. Panel, do you have any questions? Okay, do we have a motion? Yes, Yim?
I think it's a good idea that they will work out these, some of these issues. So I would defer the case to the next available hearing.
All right, seconder. Aaron, all in favor? Have your approval? Thank you.
Thank you.
Number 2017 Chiltern Hill Road. The purpose of the application to alter the existing two-story detached dwelling by constructing a rear one-story addition and a front yard parking space, also to enclose the existing front porch and to construct a new landing with stairs. With this application, we have materials submitted by the applicant, a report from Urban Forestry, and 3 form letters in support from 3 properties on Chiltern Hill. Yes, Linda Oakham.
Oh, hello. Yes, hi, my name is Linda Oakham of Ace Air Right Architects, and we're the architects for 17 Chiltern Hill Road. Our clients are looking to add just a small 1-story extension to the rear of the house to extend a small kitchen.
Yes,
as well
excuse me. Could you just give us your address, please?
at of the property, or
No,
so we are 2171
Your
Avenue.
address.
Yeah, it's 2171 Avenue Road, Suite 204, Toronto, Ontario, M5M4B4.
I don't think we need a presentation before we take.
Okay.
Before we take it into committee, do you have anything you want to say to the panel?
No, we do feel that the variances are fairly minor in nature. It's just a small extension.
Yep. Okay. Any questions, Larry?
Thanks, Chair. I'm just interested in variance number 1. You're required to get a variance for a parking space, but that's an existing condition. You already have a driveway, which looks like it's
Yes.
leading into a garage. So do you?
That's right.
Do you have any? Do you know why that variance is required?
It's actually because the existing garage is very small on the floor plan. It's only 14 on floor plan 137. It's only 14 foot 8 inches long, the existing garage, and it doesn't really accommodate a full car, most standard cars.
But in the parking area where the car typically parks, is that on private property or is that?
Yes, no, that's private property.
Okay.
Yes.
That's great, thanks.
Any further
no problem.
Any further questions? Okay. Do we have any comments, or do we have a motion? Larry?
Sure, Chair. My only concern was just a question about the parking variance, and I thought that was a reasonable explanation. The fact that the pad where the car is on private property, I don't see this as being an issue, particularly given it's an existing condition. The addition off the back is modest. I think this is a supportable application. I'd like to move approval subject to forestry 1 and 2.
Yes. Do we have a seconder? Yes, Yim? Yes. All in favor? Aaron? Yes.
Okay,
Okay, you have your approval, thank you.
Thank you very much. Bye.
Number 21, 78 Baldwin Street. The purpose of the application is to construct a new 4-story semi-detached duplex building with a front covered porch and stairs, a rear ground floor deck and stairs, a 2nd-story front balcony, as well as a rear 3rd-story rooftop deck. The existing party wall with the adjacent semi-detached dwelling, municipally known as 76 Baldwin Street, will be maintained. With this application, we have material submitted by the applicant. We have email correspondence from Transportation Engineering. We have staff reports from Urban Forestry and City Planning. Meng Chen Yu.
Hi, my name is Meng Chen Xu. I'm the agent and designer from LGW Engineering Limited on behalf of the owner of 78 Baldwin Street.
What's your address, please?
78 Baldwin Street.
No, not the address of the application, your address.
My address is Suite 405, 2347 Kennedy Road.
Okay. All right, so before we take this into committee, do you have anything you want to say to the panel?
Yes. So one thing I would like to point out is that we make a big modification before the hearing. Previous proposed building depth was 31.51 meters, and we reduced that building depth to 25.45 meters. And for the floor space index, it also being reduced to 1.09, and the total area will be 390.3 square meters.
Okay,
And the other variance will remain the same.
okay, so that's, which variances are those? Number 2?
Number 2 and number 3.
Okay. All right,
And I think we submitted a redlined agenda. I'm not sure if it's being, oh, it's, yeah. It's, yeah, that one.
okay,
So regarding the building depth, we make a big reduction from previous proposal just to align with the adjacent properties. And also from the cover letter we submitted, it can be seen, I screenshot some of the properties that have building length which is greater than 26 meters. So we think the 25.5 building depth will be acceptable and reasonable along for this Baldwin Street. And also, as you can see, for our lot, it's quite long lot. It's almost 188 feet long compared to the adjacent lot at, I think it's the adjacent 80, number 80. The lot is much shorter than our lot. And just by calculating the depth percentage, our building depth is less than, it's 44% of the lot depth, while the adjacent property is more than 50% of the lot depth. So I think our proposed building depth is acceptable and it will not adversely affect the adjacent properties.
thank you.
And-
Panel, do you have any questions? Yim?
Oh, just one small question. The comment from transportation, they ask you to get a permit if you're going to do any work beyond your property. Is that part of the condition that you agree to? Yeah?
Yes, yes.
Okay, so we'll put that.
Okay, any further questions? Larry?
Just a quick one. So you are a semi. Have you had discussions with your neighbors and particularly adjoining semi?
Yes, we've already discussed with our neighbor, and we will finish their, like, the party will remain as is, and we will finish all the exterior face for the other, for the adjacent property to make sure that it will look beautiful and elegant.
Yeah, is the adjoining attached owner, are they satisfied?
Yes.
Did you get anything in writing from them?
Not yet, but we can submit that later on if to the planning department
Yeah,
if required.
I would think it would be a good idea to submit it to the building department.
Okay.
You don't want to have some problem with your neighbor later on.
No problem.
Okay. All right, do we have?
One last,
Yes,
Chair, if
go
I
ahead.
might. So I know you do have a third-story balcony. I think we'll probably make a condition to screen the sides of that because you are pretty close to your neighbors. So are you comfortable with that?
Yes, and actually in the cover letter, we've also mentioned the privacy screen. We're agreed to add that.
Oh, I missed that. Okay, great, thank you.
So it's on the east and west side?
Yeah, is it, so planning didn't mention that in their report.
Yeah, I think it's east-west, yeah.
Okay.
Okay, do we have a motion?
Sure, I'll move that motion, Chair. Again, I think, given the lot configuration, it is very deep, as the agent noted, and I think it can accommodate that. Part of the new build will back onto a lane, which is fine. And with the screening of the second or third floor balcony, I think it is supportable. So I'll move approval subject to forestry condition number 1, and forestry, for the record, also included an advisory memo. I'm sure the agent has seen that. And planning conditions tie it to plans.
The transportation.
Is there a transportation condition?
Advice, yeah, a comment, yeah, they said that they, yeah.
Oh, they just have to submit an application. Okay.
All right, and the application as amended.
As amended, thank you, Chair.
Okay. You second that, Jim?
Yes.
All in favor? Have your approval? Thank you.
Thank you.
Number 22, 820 Yonge Street, purpose of the application to alter the redevelopment standards for parcel A, 51-story and 65-story buildings, towers A and B on the west block, and 75-story building, tower C on the east block, approved under site-specific bylaws 661-2020 and 662-2020. The podium level office spaces within towers A and B will now be for residential uses, also to increase the residential gross floor area and the combined residential, non-residential gross floor area. With this application, we have material submitted by the applicant, and we have reports from planning and development coordinator, property planning and development. Okay, so Benjamin Larson.
Through you, Mr. Chair, I think we may have just connected. Let me see if this works. Through you, Mr. Chair, let me just give him one more call, and we'll try again. Benjamin, you've been unmuted.
Larson? Hello, it's Benjamin Larson.
Yeah. Can we have your name? Can we have your address, please?
Certainly. That's Benjamin Larson from Hunter and Associates. Address is 15 Gervais Drive, Suite 503, Toronto, Ontario.
Okay. So perhaps you could just give us a very short synopsis of why you're asking for these variances.
So it's on behalf of QUEENSDALE, the owner of the site. They went through site-specific rezoning approvals to allow the towers that were just at the beginning of this hearing. And of why we're here today is to seek permission to convert the requirement for non-residential office space in the building to residential uses. It's something that we have presented to city planning in advance of filing the application. They've indicated no objection to it. And I've provided a fulsome planning rationale, which is on the committee's file, which justifies why, in my opinion, it's an appropriate, minor, and desirable change for the site, given the shortage of housing in the city and the difficulties in fulfilling office space on sites in the city.
Okay. Any question, panel?
Chair.
Larry?
So just to be clear, you are eliminating all of the office use that was in the original site-specific bylaw?
There was, in the site-specific bylaw, a minimum requirement for office space, and that is what is being eliminated. It is worth noting, though, that there is ground floor retail space, as well as a below-grade concourse level, which is being maintained. And if you look into the background of this site, you'll notice that the owner, KingSet, retained a very large non-residential office building at the northwest corner of Yonge and Bloor Street, and that's being retained as part of the project. So, yes, in short, the owner is looking to remove that minimum requirement of office space, but there is still a non-residential component that will be retained on the site.
Great. I'm sure that would probably be consistent with what is going on in Yorkville. The 4 additional floors of residential, what's the unit count on that, and what's the type of units?
The type of units will be typically the 10% 3-bedroom ratio with the 15% 2-bedroom ratio. And the total unit count, if you would give me a moment, I could look into the file to see what that would be. I do not have it in front of me at the moment, though. It would be in the range of 1,100 units.
Sorry, 1,100 additional units?
No. There would be an additional of approximately 80 to 100.
Okay. And that mix is, city planning is comfortable with that mix?
Yes, we've discussed this project with city planning. They're indicated no objection to it. It's the same city planner that's handling the existing site plan applications for the site, so they're fully aware of this.
Okay, thanks.
Okay, you said that you have retail on the ground floor and a concourse in the basement. Are the concourse retail as well?
The concourse is retail uses.
Okay, thank you. All right. Yim?
Yeah, there's a planning request that it would, if we're going to approve this, it will tie to drawing A301. That's to indicate the height of some of the building, right? Yeah.
That's correct. So that condition is, so what KingSet did, they indicated that they would lower the center portion of the podium by 1 floor.
Oh.
But we couldn't submit a revised zoning map because you can't lower a height through a variance. So the way to implement that lowered height in the podium was a condition. And that's tied to plans which show the lowered podium height.
Okay, thank you. Yeah, that's what I clarify that.
No problem.
I'm ready to move to have a motion.
Okay, go ahead.
Yeah, I'd like to have a motion to move for approval, a condition with the planning condition tied to drawing A3.01, and also subject to a TTC review.
Okay, do we have a seconder, Aaron? All right, all in favor? Larry, are you?
Yes, sorry, Chair.
Your hand didn't show up on the screen. All right, you have your approval, sir. Thank you.
Thank you all.
Next item is 23871 St. Claren's Avenue. Purpose of the application to construct a new 3-story, 6-unit apartment building with front and rear 2nd-story balconies, front and rear 3rd-story balconies, and new north and south side entrances. This application is expanding on the already approved Committee of Adjustment application A0968/19 TEY and A1273/21 TEY. With this application, we have material submitted by the applicant and opposition from 52 Primrose Avenue. Mr. Gain.
Yes, Good afternoon, Mr. Chair. My name is Trevor Gain. I'm the agent here on behalf of the owners.
Okay, and your address, sir?
10 Celebrity Place in Markham.
Okay. Can we just have a very brief explanation of what was approved previously and what you intend to do now?
Yeah, certainly. So as mentioned in the description, this application, or this property rather, was before the panel back in 2019. At that time, we got approval to build a 2.5-story duplex on the lot with a few variances. And then again, it came back to Committee of Adjustment in 2021 where we converted the garage into a laneway suite. Given the changes in the Ontario government and legislation under Bill 23 and the More Homes Built Faster Act, the new owner is now looking to sort of maximize on this intensification. So the proposal before you now is to take this duplex, 3-bedroom duplexes, and convert them into 6 units. So the designers very cleverly worked this out without any change in massing. So all of the previous, the footprint, the height, the setbacks, all works again, but it's just a reapproval given it's a definition change from duplex to apartment buildings. So the variances in front of you, the 8 variances, like I said, everything was approved before. Variance 6, which is dealing with building depth, variance 8, which is dealing with side yard setbacks, are exactly the same. The floor area, the floor space index, which is variance 7, is essentially the same. We were approved before at 95%. Now we're at 1.14. And that's simply because the basement is now included in floor space. It's not exempt as part of a dwelling was. The remainder of the variance, you have a pair of decks. Again, that's a definition issue where decks are allowed projections on dwellings, detached, semi-detached, whatever. Not the case in apartment buildings. And then the other handful of variances are really just dealing with landscaping. So we have no change in the actual square meters of landscaping. But again, because of the decks and whether they're exempt or not, in apartment buildings they're not, so now that kind of hard surface, which was exempted from the previous approval, is now included in the landscape calculation, so we have a minor variance under those. So all in all, we think it's pretty minor. It's really just a definition that's causing this, and it's a great location for this intensification at the end of the road. It's wrapped by 2 lanes, and we have another 3-story multiplex kind of right beside us. So planning seems to be good with it. No comments from city planning, and we seek your approval.
All right, Mr. Gain, what happened to the laneway suite?
It's still there, or it's approved. So both the duplex and the laneway suite went in for building permits and were put on hold. But the laneway suite will still be there. We just need to pay the development charges to get that going. But that is part of this application, but according to planning, it does not need to be reapproved.
Okay, so you're going to have 6 units in the apartment building and 1 unit in the laneway suite?
That's correct.
Okay. Now, I'm not sure I heard you correctly. Variance number 7, I thought you said floor space index equal to 124 times the area of the lot. My application reads 1.14.
Yeah, that's correct, 1.14. Maybe I said 124, maybe you misheard it. I'm not sure, but we're going by the variances.
All right. Maybe I misheard it. Okay. Panel, do you have any questions? Yes, Yim.
I still got a little bit confused why you're building a laneway suite, but why is it not part of this application?
Been approved.
It's been approved?
Been approved on a previous application.
Oh, so they're not making any changes on laneway suite?
No.
Okay.
Chair, just a question on again, the balconies. Feels like that's my job today. I see on one side it's not an issue, but on the side facing 873, I think there may be a bit of an overlook issue, so maybe we could put screening on that side. I don't know which side it is. Yim always tells me what side it is.
It's the south side.
The south side?
Yeah, all right. No, no, sorry. Yeah, it's the south side.
North side.
Is it north side? I think the agent just piped in.
Yeah, but then north is.
Yeah, north side. North is up.
North and south, you want to.
So I don't think it needs to be on the one side where there's an apartment block on the side. I think it's just the side where 873 is on. Which direction is that?
That's the north side.
That's the north side. So I think, and again, given its rental and given that these balconies are off living areas, I think there might be a need for some privacy screen just on that side.
Yeah, this north.
Okay. So do we have a motion?
So it's, yeah, I can, you want to go?
Go ahead, Jim.
Yeah, I don't think there are any conditions except the privacy screening on the rear third floor. Is that
I think second and third.
second and third floor balcony on the north edge? That's it. That's the only condition.
Okay, you second that, Larry?
Yes, sure.
All in favor? Have your approval? Thank you, sir.
Thank you.
Number 24, 27 Southview Avenue. Purpose of the application is to alter the existing two-story semi-detached dwelling by a complete third-story addition and a rear one-story with a roof deck above, also to reconstruct the front porch and stairs. With this application, we have materials submitted by the applicant. Mr. Dome?
Yes, can you hear me?
Yes, we can.
Yes, my name is Joe Dome, 133 Torresdale Avenue, agent for the owner.
Okay. We have some opposition, so we need a presentation.
Yes, the owners would like to construct a third-story addition and a rear one-story addition to the existing two-story dwelling to accommodate their family livability needs. Variance number 1 refers to the proposed FSI of 1.02. As a point of reference, close by on the same side of the street to the east, number 9 Southview Avenue was approved for an FSI of 1.12. And around the corner to the south, 105 Bartlett Avenue was approved for a 1.4 FSI. Impact is mitigated by the fact that the proposed dwelling length, including the rear one-story addition, is within the 17-meter bylaw, and the second and third stories are only 10 meters in length. No height or side main wall height variances are being requested. Variance number 2 refers to the proposed porch encroachment into the front yard setback, and this, along with variance number 3 for the proposed stair setback to the front lot line, is entirely consistent with the streetscape, being a common existing condition for many of the dwellings on that stretch of Southview Avenue. And I would just like to make one amendment to the wording of variance number 3 for the porch stairs, which should read front north lot line.
Okay. Right. Okay. Nico Zuko?
Nico, you've been
Hello, you can
unmuted.
hear me?
Yep.
Hello?
Yes, we can hear you.
Okay, great. Thanks for confirming. I'm just a neighbor to this project. I
right,
don't want
sir,
to give the project a hard time or anything.
All right, Mr. Zuko, can
Yes,
we have your
hello?
name and address for the record?
Oh, yeah, of course. Yes, my name is Nico Zuko. I'm at 123 Bartlett Avenue, so I'm directly adjacent to the property in question. So I don't want to give this project a hard time. At the end of the day, it's up to the panel to decide if this variance is minor or not. I just want to provide some extra context to kind of the FSI increase, and that it's a bit of a unique location for this property, and
directly, it's kind of on the corner, and to the left side of, kind of the west side of the property on the side lot there is about 4 or 5 yards. So the impact on that does seem a little more significant as opposed to the property was kind of in the middle of the block. So yeah, so just want to give some extra context to kind of how that, like, extra FSI, the 3rd story addition or 1-story addition to the existing property, how that might actually be a pretty significant impact to those yards that are right up against the property.
Mr. Zuko.
Yeah.
Mr. Zuko, we're having trouble understanding you. Perhaps you could go back to the beginning and just summarize what your objection is.
Slowly.
Yeah, slowly, and speak a little bit louder, but slower.
Okay, sounds good. Yeah, sorry about those difficulties. Yeah, so my objection is mostly towards the increase of FSI to this project. In this project, mostly just because the context of the lot is a bit unique. It's the house is not in the middle of a block; it's actually at a corner, and on the west, on the side of the property is directly adjacent to about 4 yards. So the extra FSI that comes in the form of an extra story, and the addition to the back there is right up against those yards, and there's about a lot of concerns about kind of how imposing that is, and the impacts on shadows and views and privacy that would have on the yards. So yeah, recognizing that yes, there is precedence for this FSI, but also just the kind of the unique position of this property. Yeah, so that is all I have to say. Thank you.
All right, thank you. Anybody have any questions, panel? Okay. Shirley Hung. Oh, she's not here. Not here? Okay. Mr. Dome?
Yes. I would just like to respond to the neighbor's comments, and we thank the neighbor very much. I would like to address the comment on the impact of the FSI. So as I did mention that there were other FSIs in that range approved on the street, number 9 Southview Avenue, approved for a 1.12 FSI, and around the corner, 105 Bartlett Avenue, approved for 1.04 FSI. And also, just as far as the massing impact of the dwelling, we feel that it's mitigated by the fact that the 1-story, the entire dwelling length is within the bylaw, but also the fact that the 2nd and 3rd story are only 10 meters in length. So that helps to reduce that massing, and the 1st-story addition has only that 1-story massing. And I would also like to mention that the owners have discussed the application with their adjacent neighbors at number 25, who did express their support, and they've also had discussions with the neighbors at 23 and 21 Southview, as well as on the west side at 129 Bartlett. And so they didn't have any concerns for the application. But overall, we feel the application is quite reasonable and minor in nature. I'd be happy to answer any further questions.
Yeah, what's your existing floor space index?
I believe it would be about 0.6 range, but it's basically adding that rear 1-story addition and the 3rd story on top. But again, no height variances being requested or length, and there's no side main wall height variance as well.
Okay. Any questions, panel? Can we get Aaron on the screen? Because I can't see him. I don't know whether he has a question or not.
Up there.
Oh.
I'm here. I'm listening.
You're not on my screen. That's a problem.
You might have to turn left and right. There are some buttons over there.
Okay.
Yeah, you also got pushed to the side on my screen as well.
Yeah.
But I can see you if I scroll it.
He's over here. There he is. Good. Okay, thank you. So you don't have any questions, Aaron?
No, I don't. It's very straightforward.
Okay. So somebody going to make a motion?
I think Aaron should.
Aaron, make a motion, Aaron.
Okay, I'll make a motion to approve the application. I don't think there's any conditions. I'm trying to check. Oh,
Aaron,
yes.
do you think, I noticed that there's sort of like a rooftop deck over that first story addition. Particularly given the neighbors along that row on the other street have raised concerns. I wondered, do you think it would be worthwhile putting screening on that?
Right, I think that's a good idea. We'll put it at the
east and west side?
East side. Yes, east and west side. At the roof terrace. That will be the only condition added to this application.
Okay. And Larry, you second the application? All in favor? Have your approval? Thank you. Number 20.
Thank you very much.
Number 25, 157 and 159 Delaware Avenue. The purpose of this application is to construct a new 3-story detached apartment building at the front of the property with 5 dwelling units, including front basement terraces with walkouts, front ground level balconies, front and rear second-story balconies, and a front third-story terrace. The existing 2-story semi-detached dwellings will be demolished, also to alter the existing 1.5-story detached garage at the rear of the property by decreasing its size and converting it into a detached dwelling, 1 dwelling unit with a new front ground level courtyard, a covered terrace, a side south ground level courtyard, a side southeast second story and terrace, and an integral garage. With this application, we have material submitted by the applicant. We have reports from urban forestry and community planning, and support from 147 Delaware and 230 and 257 Concord Avenue. We have correspondence in concern or interest from 236 Concord and 183 Delaware. And we have a 32 signature petition in opposition. Mr. Galbraith.
Good afternoon.
Good afternoon, sir.
Sean Galbraith, urban planner, here on behalf of the application.
And your address?
18 King Street East, Suite 1400, Toronto.
Okay, we need a presentation because we have some opposition.
Great. Thank you very much. If my cover letter could be brought up, there's some handy graphics included in that. So what is before the committee it's an unusual little property and project. It's an L-shaped property that has what used to be that's not my cover letter, what used to be an old auto body shop in the rear. So there are 2 existing buildings on the property. The existing auto body shop, this is the one there, thank you. You can see in the back there the old auto body shop, and then in the front it has a pair of semis. The north semi has been uninhabitable due to a perhaps botched renovation in the 1990s, and then the south one has 2 units. The semis are proposed to be demolished and a new 5-unit apartment building containing 2 3-bedroom units and 3 still generously sized 1-bedroom units inside. The apartment building is proposed to be expanded to sort of fill in most of the rear north driveway. The property currently has 2 driveways historically connected to the old auto body shop. You can see there's a north driveway and then a south driveway. The south driveway is secured via mutual driveway easement with the property to the south. There is no such mutual driveway to the property to the north, and so the apartment building is proposed to expand into that space. The existing footprint of the semis is proposed to be largely maintained. So the apartment building will not extend further. This is actually a really good one here. Thank you. The apartment building won't be deeper than the existing semis. It will be set back from the street a little bit more than the existing semis, and then it'll maintain most of the foundation other than where it's expanding to the north. The most notable change is in soft landscaping. The existing property has only about 14 or 15 square meters of soft landscaping, virtually none. And notwithstanding that there are a number of variances related to soft landscaping, those represent significant increases in soft landscaping on the property. Thank you. Up, please. There. So you can see there's a lot. And this isn't even all of the soft landscaping that is proposed due to conversations with city planning, which I'll get to in a sec. But almost all of this soft landscaping that is shown in green is new. There's basically a small portion of the strip in the front that is existing, and the rest is basically new. This will facilitate the planting of 6 new trees on the actual subject site itself, and then 4 new ones are proposed in the front boulevard as well. A significant improvement over the existing condition. Also in your materials, there is a revised list of variances. In conversation with planning, their only concern originally was that they wanted us to provide even more soft landscaping. To do so, we have removed one of the additional parking spaces and converted that to soft landscaping. And so there is, let's see, it should be listed as supporting material that was submitted. That's right there. If you scroll down to page 2, there's the red line version that has the increase in soft landscaping. So it's even better than it was originally submitted. We're also very happy that we've secured the support of the residences to the rear on Concord because of there's initially some concern regarding the second floor terrace at the rear single detached dwelling. It has always had a privacy screen included around it on all 3 sides. And when that was further detailed for the residents to the rear, it alleviated their concerns. That's it for me. I'm happy to answer any questions that anybody has.
Yeah, the building at the rear, is it as extensive as it looks on that drawing where it goes in an L shape?
So the existing building, if you go up a graphic there, if you can scroll up, please. To the one with the blue, there we go there. That's the blue is the existing auto body shop footprint. So large cutaways are being cut into the building. So if you can keep this image in your mind and then scroll down to the next one, to there. So the blue is what is remaining of the existing footprint, and then a large courtyard. Well, 3 large courtyards are being cut in. So the footprint of the old auto body shop is being significantly reduced, and this will be a single detached dwelling.
Okay. Yes, Larry.
Thanks, Chair. Sean, just on the 2-story portion in the rear structure, that's existing, did you say?
That is an existing 2-story portion. It's the area of the two-story portion is being reduced. Its height is being increased a little bit.
So how would you say this would compare to the average or as of right garden suite?
Give me a second.
Would it be a little larger maybe, or about the same size?
It would be a little taller than a garden suite. It backs onto a series of garages to the rear, and obviously it has no windows facing that side. And again, we've secured the support of those neighbors that it backs onto.
Right. Okay. Thanks.
I have just a very quick question. I must have missed what you said because I try to find out how many units are there totally and what kind of units they are. Are they?
Sure. So thanks for the question. First, Mr. Clay, there is no variance for the height of the two-story portion at the back because it's considered a single detached dwelling. This is a unique property where you have a single detached and an apartment building on the same lot, and so we have so many variances because the standards for both of those building types all apply, even when they contradict each other.
Right.
So to the other question, so in the apartment building, there will be 5 units, all with elevator access, be future-proofed for aging in place. 3 of the units will be 1 bedroom, the smallest of which is over 600 square feet, so still quite generously sized. Okay. The other 2 1-bedrooms will be 1 bedroom plus den, and then there'll be 2 3-bedroom units. Very large 3-bedroom units, over 2,000 square feet. And then the building in the back will be a single detached dwelling.
Oh, single detached. So altogether on the property, there will be 6 units. Yeah. Okay. Thank you.
That's correct.
Okay.
Through you, Mr. Chair. Sorry, I just, has the applicant gone through the revisions that have been made?
No.
Okay, perhaps maybe that may help because we do have some speakers in concern and opposition.
So the only notable change is that one of the parking spaces was removed and converted to soft landscaping. It's right in the middle of the image that's on the screen. And then so that change increases soft landscaping, and so that changed, I think, 4 of the variances.
So please tell us which ones they are and what changes.
Sure thing. You have the red line strike-through version before you. It's variances. First is variance number 12. In that case, the soft landscaping will now be 39%, or 262.62 square meters. Variance number 13 will be 47%, or 192.4 square meters. Variance 14 will be 29%, or 323.76 square meters. And variance 15 will be 42%, or 236.3 square meters. All of which are obviously improved over the existing proposal.
Yes.
And this was as a result of discussions with planning who support these changes.
Okay, thank you.
You're welcome.
Ann Ball.
Sorry, through you, Mr. Chair. We have Margaret here in person, so we'll hear from Margaret first.
Okay, so my name is Margaret School. I'm the owner of 236 Concord Avenue. I'm the garage that butts against a 2-story garage family unit. And the reason I'm here is I'm representing 3 other neighbors that their garages are adjacent to the 2nd floor terrace. And it's in regards to the privacy screening. Do you need the names of the other 3 that addresses or
Yes,
names?
I believe it would help.
Okay, so representing Catherine Rogers, she's 226 Concord Avenue. Hogan, sorry, oops. Then there is Dominic Irulo, 230 Concord Avenue, and then Giovanni Ienco, 234 Concord Avenue. So our garages butt against the the two-story garage unit plus the second floor terrace. And we are confirming that you guys have received the update to the privacy screening, and this privacy screening is to be a brick wall. And we are okay with the...
Is that your position, or is that an agreement you made?
It's actually, so Dominic Irulo had a chance to speak with Pamela Blaze, and she said that, and I will quote this, "After checking with our architect, engineer, and planner, I'm happy to report that we can make this change to address your concerns. A brick wall addition to be constructed on top of the existing brick parapet, bringing the total height of the screen to 2 meters from deck level." So originally it was privacy screening, it was cedar. Now she said that it was submitted, the drawings were resubmitted to the Committee of Adjustment. We just want to make sure that you've received it and that that is the final version of the privacy screening.
You have the date that the drawings were submitted, or the date of the drawings?
I can't say exactly the date, but we got notification on August 30th that she sent us this email, and it was also sent to Sean. So I don't know what day it was sent. That was not included, the date of submission was not included.
Yeah.
Okay, thank you. Okay, Ann Ball?
Anne, you've been unmuted.
Thank you. Thank you very much. My name is Ann Ball, and I'm at 170 Delaware Avenue. I'm directly across from 157, 159 Delaware Avenue. And I'll be brief here. I wanted to, first of all, thank you for the opportunity to speak to you today about the plans to develop the property. As you know, some of the neighbors on Delaware Avenue submitted a petition, and I'm speaking on their behalf. And why we support the overall project, especially because Toronto badly needs housing, and it will be an upgrade to what is there now, which is 2 semis and a garage that need help. We are concerned about 3 things. One is the parking, which Sean indicated before has been removed. We're very grateful for that. The second is the disruption to the street, to the neighborhood during the demolition and the construction, very tight neighborhood. And the third one is, of course, variant 17. And variant 17, it's for the new apartment building, which effectively removes access for our neighbor to her garage. Many people have lived on the street since the 1960s, and they recall that the neighbors at 163 Delaware had a right-of-way going back at least 41 years. Right now, Mei Xing Wei and Shu Feng and their 4 children have lived at 163 Delaware for just over a year.
Okay.
Their first generation.
All right, Ms. Ball, do I understand that this right-of-way is not registered on title?
Truthfully, I don't know. I've been talking to Mei Xing. She is totally baffled by the process. She's scurrying to try to find this information, perhaps, but I don't. She's just got back from China, which is why we sort of requested a delay for us to work with her and help her get this material together. She said she has a survey, which I haven't seen, but
All right,
sorry.
but as I understand it, there's a letter in the file from the owner's lawyer indicating that there's nothing registered on title with respect to this right-of-way. We don't have a mandate with respect. This is a legal issue. This is not within our mandate. It's something that has to be worked out. I think your advice to the owner of the adjacent property is correct. They have to get their papers together. They also have to consult a lawyer, and that lawyer has to get in touch with the lawyer for the applicant. Mr. Galbraith, do you have any information with this aside from what's in the file?
No, my understanding is that there is no easement on title for the north driveway. There is for the south. And also that the neighboring property to the north still has a 2.2 meter side yard setback, which is sufficient for a driveway to access the rear of the property.
Okay, so my question is, as I understand it, they're complaining that they don't have a turning. They're not able to turn into their garage. They have to go without going on your client's property.
That might be the case, but that's not an uncommon situation in tight downtown neighborhoods. There's, to put it bluntly, there's no right to trespass across another property to turn your car around.
Yeah. So, are you making any changes that would affect the current situation?
So the proposed apartment building will be extended north to 0.45 meters from the north side yard setback. So to the extent that the neighbors have been driving across the subject site, that will not be possible anymore. But again, they will still have access to the rear of their property, wholly within their own property limits.
Okay, thank you. Ms. Ball?
You're welcome.
Ms. Ball?
Yeah.
Yeah. Are the neighbors only complaining about the access at the rear to their garage, or are they complaining about the driveway too?
Well, they cannot get the car that they have now, through that 2 meter driveway. They have a garage at the back, which is not shown at these plans, but it's blocked their access to they can't get to their they can't get to their garage with their car. They'd have to buy a new car. And I just think that there has to be another solution of some sort. And to build take the new building all the way to the property line, which causes so much distress for these people. Well, when, historically it's never been an issue.
Okay, so are you, I think you suggested that this matter be deferred?
To facilitate a conversation and to give Ms. Zing time to get a lawyer, to get her papers together, and feel satisfied that she's not being really shafted here, frankly.
Okay, so I would think, we can't solve this problem at the committee.
No.
So I would think we need a deferral, or you or your neighbor needs a deferral to try and get this sorted out.
Thank you.
Okay, so let's just, Mr. Galbraith?
Hello, I'm back.
Yeah, so Mr. Galbraith, are you opposed to a deferral? I don't think we can't sort out the right-of-way issue. I don't know.
With respect, my clients are not in support of a deferral, and frankly, a deferral will not solve it. The neighbors to the north have sufficient width on their property to maintain a zoning legal driveway. They have enough width, according to the zoning bylaw, to get to their rear garage. I'm not sure what the purpose of that deferral would be, given that my clients do not agree to give them a right-of-way across their property, a right-of-way which they're not entitled to under law. And so...
well, it's not a question of your client giving them a right-of-way. It's a question of whether they have a right-of-way by prescription. Because as I read the papers, and as Ms. Ball said, going back to the, I don't know, 80s and 90s at least, that the people that lived there before the current owner used to drive over your client's property to get to their garage. If they can establish that, then they may have established a right-of-way.
In the letter that has been provided to the committee addresses this specifically, and that it's, the land registry, the land titles, registration, there simply isn't one. They're barred by statute from even trying to, frankly. But in any event, this is beyond the scope, respectfully, of the committee. There's no variance before committee that is tied to that. There's no, for example, side yard setback variance required.
Well, I don't.
Mr. Chair, I just want to add that I'm looking at the survey dated on April 24th, 2023, which is basically the survey that is submitted by the applicant. There's no right-of-way or any agreement noted on the survey. And if there is one, normally it would be discovered and shown on the survey. So I guess the question is, if there's a neighbor saying that there's a document that might exist, they still have the right to bring it to the city to oppose the construction.
Yeah. Chair,
we haven't.
I don't think we should defer it because somebody said they have something that might exist.
Sorry.
Chair, I tend to agree with Aaron. I'm not sure a deferral in this instance would satisfy the concern, particularly when we have documentation from counsel for the applicant stating that there is no right-of-way. And I also am a little bit concerned about, I appreciate the neighbors' representing the interests of the adjacent neighbor, but we haven't heard from the adjacent neighbor directly. And I don't see anything in the application which would suggest, and Aaron's right about the survey, it doesn't appear to show any right-of-way on the survey. So I'm happy to proceed with this application and not defer it.
But can I add something? But a survey is one-sided, though. The opposite property can do another survey showing something else.
But I think Aaron's right. There is a legal remedy if the neighbor adjacent feels that there is an issue with surveys, then that neighbor can proceed to get a survey.
Yeah.
Well, with all due respect, the survey doesn't show unregistered easements. With all due respect to the lawyer's letter, it's misleading because it says this person bought the property in 2021, and therefore it doesn't have a right to an easement because it's been foreclosed by the fact that the property is registered in land titles. The fact is the property is registered in land titles subject to any easements. that might be claimed. And the owner of the adjacent property, in my opinion, still has a right to bring forth a claim for an easement, but they're going to have to go back to the previous owners, and before the property went into land titles, they may still be able to prove that there's an easement there. I don't know what it's over, and I'm not sure why they can't make the turn into their garage, but it's I think there is an outstanding legal issue here that has to be resolved. So, and we can't do it. We don't have, we're not giving legal advice here. So,
if I may just add one more thing. When my clients, they haven't sprung this like just recently on the neighbor to the north. They first presented plans to the neighbor to the north a year ago. The neighbor has had plenty of time, if they wish to obtain a legal opinion in that time, to do so. The first that they heard about it was not from receiving the public notice from the city. If they haven't availed themselves of, in the last year to do so, then I'm not sure what to say about that. If that was their concern.
yeah, well, all right, let's go back to Ms. Ball. Ms. Ball, can you just tell us why the neighbors of 163 haven't responded? I wasn't aware that this project was brought to their attention a year ago.
I'm sorry. I've been talking to Mei Zing, who is she's the owner. She's been in China. She just came back a couple of days ago with her 4 kids. She has told me, and again, language is a problem. I'm not gonna, I'm not gonna lie about that. I don't know. She says that nobody's ever contacted her ever about the property, that she has a survey, and that I just think a conversation, if it could be deferred, if they're not starting construction or they're not starting to go ahead in the next couple of months, would just resolve this whole issue for her. She can't get her car between her house and where the new apartment would be to get to her backyard. That's the issue. It's too wide. And I guess you could say, well, it's a legal issue. She should have done it before. She could go to a lawyer. But just in the interest of trying to work this through a bit, I think a deferral to have a conversation. I'll get her a lawyer. We'll sit down and sort of figure out if there's anything can be done. We'll see what paperwork she has and take it from there.
Okay.
That's my...
All right.
Yeah.
Let's just go on to the other people in opposition and see what their position is. So is Ming Wei, is she on the line? Okay, let's hear from her. That's the neighbor. Okay. You may have to translate, Yim.
Hello?
Yes?
Hi, actually my name is Mingze Wei, but my English is a problem, so I always end up hearing. But I couldn't understand so totally, and today I just hear about the outline about my neighbor, and actually if someone who can speak Mandarin is very helpful for me, but I don't think so right now. So I just came back from China a couple days. So yeah, I hear someone, like the name is Shang, told the hearing. So 1 year before we talk about each other. Actually, if I understand, I couldn't understand totally. How come we talk very, clearly. So the problem is my language is not English. My first language is not English. I bought this property 2021, and we have 4 kids. We are newcomer from Beijing to here, and I love this community, and also I love this house because they have a big long driveway. It's very convenient for our family. We need it.
Okay. Have you discussed this matter with a lawyer?
Yes, but they need time. I discussed, first I got my survey, and they will give us exactly what's the line, survey line. But I still need 6 weeks to get my survey, you know. And then if we have opposite opinions, I will hire my lawyer for sure, yeah. So right now, actually, I couldn't understand the totally things. You know, because of the language problem.
Okay, thank you.
I think I just want to add that I think you have the right to ask for a translator. Am I right?
Request, yeah, they can request a official translation, I think, but you have to be,
Yeah, maybe next
you
time
have to
you
be
should-
ahead,
you should
yeah,
ask for that.
in advance. You have to ask in advance so it can be arranged, but I at this time, I sort of, if we're in committee, I can.
No, we're not in committee because there's just 3 other speakers.
Oh, okay.
I think we'll just go on. I understand, Ms. Wei, your problem, but let's just move on with the rest of the speakers and see where we go. Claudia Rosa.
Hello, and thanks for giving me the opportunity to speak. I just heard about this project when I got this in the mail, and to be quite honest,
Can we have your name and address, please?
Absolutely. It's Claudia Rosa. I'm 248 Concord Avenue. I'm just behind this property. And I'm also going to just indicate that the garage has already been wrecked. I've also been getting a lot more rats on my end. The reason for my call is that I really don't know how to read site plans, and I'm wondering how is this going to directly affect 248 Concord Avenue? Am I going to be having a 2-story house behind me with people peering into the backyard without a fence? Is that the proposal?
Well, you put your questions. We'll have Mr. Galbraith answer them. Is that your question?
Yes.
Okay.
I'm just wondering how this is going to affect my property.
Right, thank you. Urella Gagnon.
Hi there. Oh, can you hear me?
Yes.
Hi, I live in the community. My name is Arella Gannon. My address is 2 Macklem Avenue, and I'm very good friends with the person who lives. You see that L-shaped structure? The building that's right in the middle of that L is my friend Sean, and he's disabled, and I'm his close friend, so I spend a lot of time there. They have a shared driveway. The entrance into this condo building is through the shared driveway. He's had a stroke. He's had some medical issues and has not been able to participate in this until just now. And having this extra building behind his property that he's had for decades, right on the property line is going to be problematic. They took down the building that had been the garage in a hurry because I understand that it was a historic building. But the problem I'm seeing is that to put this kind of development in the middle of a block is problematic. I think also designing this so that the main entrance is through a shared driveway with Sean Vanass is problematic. I think also the scale of this, it's single-family dwellings mainly on this block. I'm a board member of the Building a Better Bloor Dufferin and also Community Spaces Land Trust. And Sean is one of my closest friends. So I just wanted to bring up a few of the issues. The scale of this development seems really wrong. There are so many variances that I just don't understand how we have building permits and also calling it the five dwelling unit, and then they finally bought the property behind Sean's house, and so this application is for 2 properties just north of Sean's house, and then the property behind Sean's house that I guess they're assembling it as a 5-unit apartment building plus 1, so it's 5 plus 1. It all sounds kind of greedy. How much money can we get out of one hunk of property? And I just don't think it's right for the community. I guess that's my points mainly.
Thank you. Sean Vanasse?
Hi. As was just indicated, I live next door at 155 Delaware Avenue, Toronto. There is stated a shared driveway between my property and the northern properties. This construction will tear down the 2 semi-detached homes built further north, making a huge condo corporation building, and its sole access point will be the shared driveway, which will put an incredible amount of traffic on it and potentially eat into the very small amount of parking I have at my rear. And I'm a person with disabilities, having just recently received a release from hospital, so having the need for parking is necessary. But there's also a degree of concern I have, along with Arella and others, that this is an enormous project for a street block that's both quiet and comprised mostly of single-family homes, and to put a 5-unit condo building in a huge building in behind it, which has 0 clearances. It butts right onto our property lines, mine and the next 2 properties, has serious issues of concern about both privacy, etc., from the deck on the 2nd floor and the 2nd floor building itself. Notwithstanding issues of concern about them being historical represents, either listed or whatever, about both the initial buildings and the rear building having been probably a dairy at one time. This is a gross overstatement, a gross overbuilding of the area. I also have been in communication with my immediate neighbor, which is Mark Hammond, the ex-CEO of the hell is it called? The entertainment spot downtown on Front Street. But he too objects decidedly to this project, and there may be additional concern from the next neighbor as well, both in terms of the size and the nature of this building, and also in the privacy that it sort of invades both of mine and their properties. Not to mention the fact that there's 0 clearance. It goes right up to our property lines. These are just a few of many concerns I have. Okay. Also, that it's just occurred, this meeting is just occurring days after Labor Day weekend, really doesn't provide much opportunity. I've been sick for the last several weeks, and it's just not very much opportunity to address this. And I only just received these documents outlining what the program, what the plan is for the development recently. And I too request a deferral, just simply to address this more thoroughly and to speak with the developer and to also address other neighbors.
All right. Thank you, sir. Mr. Galbraith?
Thank you very much. I think I have the list of comments. First, there is no lot assembly here. This has all been one property going back as far as the lot has existed. It has had 2 buildings on it for decades and decades and decades. There is no impact at all to the mutual driveway to the south that is being maintained, and it's an easement there. It's a legal easement. Nothing can be done to it. So parking access to the property to the south will be maintained. All of the entrances, or the entrances to the apartment units are in the front. No, there are no entrances on the south side. Well, so I mean there is a secondary entrance, but the main entrance is to the front, and that's where you would access, for example, the elevator. The privacy and overlook question regarding the second floor terrace for the rear building, there is already a privacy screen provided for on all 3 open sides. And so there will be no overlook into the yards at 155 or 153, et cetera. And it's set back almost 4 meters from that shared property line. The existing walls of the auto body shop are being maintained, with the exception of the front wall, because that had to be removed for environmental mitigation access. It will be replaced, slightly set back a little bit, but largely in the same place. All the other walls are existing and are in existing condition. With regards to the massing of the front building, I heard it called a huge condo. There's no height variance required for it. The height is entirely permitted. The building depth is only 15 meters. If this was a pair of semis, they could go back 17 meters, and it's entirely in keeping with the existing structure because it's largely using the existing structure's footprint. With regards to historic buildings, there are no historic designated or listed buildings on the property, especially the auto body shop. Heritage Services have expressed no concerns, neither has planning with this proposed development with regards to heritage. So I don't believe there are any concern there. And as for communication, I personally delivered letters to neighbors more than a month ago, I think. All neighbors within the notification radius on both Delaware and Concord. And I don't believe that the neighbor Sean has reached out, though I did speak to. I spoke to someone. I apologize. I don't have the name of one of the neighbors to the south, and explained the privacy screen to him. And I believe the owner Pamela, she's also spoken with Sean. So this isn't. I'm not sure why. The comment was made that the first he heard about it was from the public notice. I think that was all of the comments. But if I missed any of them, please let me know. I'm happy to answer those too.
Perhaps, Sean, you could just repeat your position with respect to the, summarize your position with respect to the right-of-way that's not registered on title.
This has been reviewed by a lawyer who has familiarity with the land registry and land titles process. It is his opinion that there is no claim possible under statute, and I have no reason to suggest to believe otherwise. And in any event, with respect, it is beyond the scope of the committee. It's not tied to any of the variances.
Yes.
I'm not a lawyer, so I don't want to make any legal claims, but the lawyer that has weighed in says there is no claim.
Yeah.
Chair, can I ask Sean a question?
Yes.
Sean, I didn't realize this, but in your last couple of sentences, you mentioned the owner is Pamela. Is that Pamela Blais?
Yes, sir.
Chair, she is a former associate. We've done some work together in the past, and I feel it's appropriate that I recuse myself from this discussion.
Okay.
In an abundance of caution.
All right. Perhaps you could just step out.
Leave?
Yeah, I think that's the usual procedure. Okay. Aaron, do you have any comments?
Well, I think the question right now is, I don't have any issue about the development. I think it is mine. The question is whether the neighbor should deserve to have extra time with a surveyor to find out or confirm whether that they have the right to use that corner space to maneuver their vehicle. I think that's the question I'm thinking. Should we? I mean, they both deserve the right. The applicant and the neighbor both are the citizen of the city, and they deserve the same right. The question is, should we believe in the neighbors that giving them an extra 6 weeks will resolve the problem?
Okay. I can add my comment on that. I think that this is irrelevant. They can go ahead and pursue the right of way or clarify it. But when I studied the plans and proposal, and also the stance of the applicant, they're not going to give any right of way on the north side anyway. And with the proposal, it's actually set back 0.45 plus the existing 2.2 meter. The distance is about 2.6 is actually a standard driveway. So they can actually go into the garage anyway. So I do not think to pursue or to delay it because they want to pursue the status of the right of way will help or will or to change the development. I think we should hear it today. Yeah.
Okay, so I think that they have every right to pursue their claim if they think they have a right of way, but I don't think it's and I don't agree with the lawyer's letter that they don't have a claim at all. They have a right to claim whether they're entitled to a right of way or not. Mm-hmm. But I think if we approve this, it's not going to get built tomorrow.
No.
So, because they still have to go to get building permit and everything else. So I think that the neighbor would have time to consult with a lawyer, and if necessary, if they do get a building permit in time, they can get an injunction against the building until they can sort out the issue of the right of way, if there's an issue.
Yeah, if there's an issue, that's why my point is when you study the plan and the proposal, it's actually there's plenty of room to have a driveway there anyway with the proposed build even.
Yep.
So,
okay.
So I think that.
So Yim or Aaron, we need a motion.
Yeah. What I have heard of a lot of oppositions that I'm not too sure they understand fully what is in front of them. And when I look at the floor plans and actually, especially the building on the east side, and it's a great improvement actually. The existing building filled up the whole site. And the proposal is actually will create some green roof, and also with some courtyards. And actually, I think that it will improve the current situation rather than make it worse. And I think that this site has been utilized and produce some quality apartment units. I think that it is a supportable proposal, and I'm in support of it.
Okay, that's your motion?
Oh, I'm not too sure. Maybe Aaron will want to say something before. Yeah.
No, I agree with you. I mean, the only thing that was holding back me was that right of way. I just want to be fair to the neighbor, and I agree with you. I look at the site plan again. They should have enough space to go over, and I just want to talk to the neighbor. If you've discovered that there is actually a right of way, you have the right to go to the city building department and continue with the discussion with the applicant. But with the information we have now, I have no problem to support Yim's motion.
Okay.
So I think that.
We need a motion.
Yeah, the motion is to approve, but I think it's been amended, right? Some
Yes.
Some of the variance has been amended, and also, you got all the amendments, and also, I think it tied to the condition, the community planning report. We have to tie them to the plans received August 30, 2013.
I think there's an urban forestry F2.
There's urban forestry condition number 2, yeah.
Okay, so that's it. Aaron, do you second that motion? Okay, all in favor? Have your approval. Thank you, sir. Can we have Mr. Clay back?
It disappeared.
Welcome.
I didn't realize until.
Yeah, I know. Well, it didn't say her name as the owner. Okay, we move on to number 26, 108 Queensdale Avenue. Purpose of the application to alter the existing two-story detached dwelling by constructing a rear two-story addition with a rear ground floor deck. With this application, we have material, where to go? Ah, 26. I don't know what happened to my, fell on the ground. Just material submitted by the applicant. Mr. McAuliffe?
Patrick, you've been unmuted.
Oh, can you hear me?
Yes.
Okay, it's Patrick McAuliffe, 69 Harris Park Drive, Toronto, Ontario, M1L388.
Okay, we are going to take this into committee. Do you have anything you want to say to the panel before we go into committee?
Not really. I think it's pretty straightforward.
Just a quick question, very quick. You have a revised site plan. Can you tell us the difference between this and the earlier site plan? I can't find any difference, but you can tell us.
Why? Because I had to revise it?
Yes. Why do we have a revised site plan? That's what
to be honest with you, I can't remember why it was revised. It was just a minor thing that they wanted me to spell out. It was just a bit of information on the drawing that I didn't have.
Oh, okay. Okay. Because I thought maybe you knew, you can quickly tell us. I can't find the difference myself. But
okay.
Anyway.
Oh, it was minor. It was really minor.
Any further questions? Okay, do we have comments or do we have a motion? Larry?
Sure, Chair. I think I agree. I think this is a very simple and very minor application. Only 2 variances, very minor indeed. I don't think this poses any negative impact on the street or the neighborhood. I would move approval, no conditions.
Seconder. Aaron, all in favor? Have your approval. Thank you.
Thank you.
Thank you.
Okay. Number 27, 310 Woodbine Avenue. The purpose of the application is to alter the existing 3-story semi-detached dwelling for a total of 3 dwelling units by constructing a rear 1-story addition with a rear ground floor deck and a rear 2nd-story deck above the 1-story addition. Also, the existing rear 3rd-story deck will be maintained unaltered. With this application, we have material submitted by the applicant. Mr. Casson.
Hi, can you hear me?
Yes.
Oh, okay. Yeah, this is David Casson. I am the owner of 310 Woodbine. I'm representing myself today here.
Okay, thank you. This is very straightforward. Do you have anything you want to say before I take it into committee?
No, except for I just feel that it's a very simple root pile foundation, nothing serious. It's nothing spectacular compared to my neighbors. As a matter of fact, it's 1 story less than my 2 adjoining neighbors, so I'm not even building to the points that they have.
Okay, thank you, sir. All right, panel, do you have any questions, or do we have a motion?
Sure, I'm happy. Again, this one is really very, very minor. No negative impact on any adjacent properties. Very straightforward. I'll move approval with no conditions.
Seconder. Aaron, all in favor? You have your approval. Thank you, sir.
Thank you.
Number 28, 5 Greenwood Avenue. Purpose of this application to alter the existing detached dwelling by constructing a rear 1st-story addition. With this application, we have material submitted by the applicant, correspondence in support from 1 and 2 Cherry Nook Gardens. Luca Penzo.
Yes, good afternoon, committee. My name is Luca Penzo from Urban Blueprints, address 1109 Queen Street East. I'm the designer and agent.
Okay, do you have anything you want to say before we take this into committee?
Just that there was an error on the original zoning notice. So the examiner updated the notice and a new notice was submitted and put on file August 17th. Variance number 1 for building depth was removed. So there's a total of 3 variances out of 4.
Okay. So
August 17th, it's on the file.
Pardon?
It was updated to the file on August 17th. It's there.
Okay. So, but old variance number 3 has 0 landscape open space, soft landscaping. Is there
That
something?
variance is still there. It's just variance number 1 that was removed for building depth.
No, I appreciate that, but the old variance number 3 has 0 soft landscaping.
That's correct, because it's for the side yard setback, and the side yard is, it's a shared walkway. It's an existing concrete walkway that's not being changed. It's an existing condition.
Okay, is there soft landscaping elsewhere?
Yes, in the front and the back, and there's no variances for landscaping for the front or the rear yard.
Okay, thank you.
Sure. Just
Yes, Larry.
a quick question. So if you're eliminating variance number 1, you had a depth of, is your site plan changed at all, or do we have the?
No, nothing's actually changed at all on the plans. There was a zoning examiner error that I noticed.
I see, yeah.
Great.
So I had the examiner update the notice. Yeah.
Thank you.
Okay. Do you have any further questions, or do we have a motion? Yes, Jim?
Yeah, I can move motion for approval, the zero soft landscape, because the property line is right at their side yard, I think that's why. So I approve for, approved with the amended agenda, deleting variance number 1. No conditions.
Okay. Seconder? Aaron? Yep. All in favor? Have your approval? Thank you. I got a problem now.
I'm gonna leave my room now, so you guys can continue.
So I need to go to my.
You got to go into the hall.
Can't get it out here
Yeah. Makes sense.
to get my other, yeah.
No, 29.
This one. I think so. 29. Yeah. There it is.
Oh, this
Okay.
is a tough one.
Oh, you got that one, yeah. Okay, thank you.
I know this.
Okay, next item, number 29, 130 Kennedy Avenue. Purpose of the application is to permit an outdoor play area in the front yard for the existing day nursery, La Petite École. And with this application, we have material submitted by the applicant. We have correspondence and support from 35 High Park Avenue. I don't think it's close by. And a concern from Choice Properties, Loblaws Property Limited, 2187 Bloor Street West. Mr. Fung.
Hello, can you hear me?
Yes.
Hi, yeah, I am Jason Fung, the architect and agent on the file, located at 675 King Street West, Toronto.
Okay. There is opposition. So perhaps you could just give us a brief presentation.
Sure, yeah, no problem. Thank you, Chair and committee members. We need more daycares. And the previous, so we previously had a 2-story enlarged daycare center without conditions approved in 2022. But due to forces beyond our control, that proposal had been significantly scaled back. Currently, the La Petite École can handle 24 children, but without outdoor play, they cannot provide full-day daycare, only half-day. So this proposal is a small 540 square foot outdoor play area suitable for 8 children, fully supervised on 3 rotations, so hence the 24 children. And as per the reviews previously, in the area in the front there, those are not required parking spaces currently by law. There are 2 letters, so there's a letter of concern and a letter of objection. The letter of concern is from Loblaws No Frills across the street. Their only concern is they have truck noise, and it is nothing to do with their loading, the actual truck's movement, path, anything like that. They just quote that truck noise is loud, and they're saying they have a concern with that with the children. We fail to see how that has any impact on our property.
Mr. Fung, I think it would be better if we heard that from Mr. Wright, and you can respond to it after he's made his submissions.
Sure. And then In terms of the letter of objection, that's from 117 Runnymede. That's simply a resubmission of their original objection to our 2022 second story proposal. Their letter is dated October 2022, and it also previous committee file number. So, I mean, it doesn't really address the one variance for us.
Yeah. Okay.
So, I mean, we feel this variance is very minor, and would greatly appreciate your support. I can answer any questions or go from there.
All right. Pat, Larry?
Chair, thanks. I recall this application in the past. So you said the approval that you received previously has not or will not proceed. Can you just hum a couple bars around that? Like what's happened? Because as I recall, that had play space included for the kids.
Yeah, so we had designed a second story outdoor space on the rooftop. It's financially just like the construction costs went through the roof, and it's not viable at this juncture. And on top of that, with the $10 day daycare announcement from the federal government, just to stay competitive for this business, the business owner needs to somehow provide full day daycare to just keep going. So that's why it's been scaled back. The larger vision potentially might be in the future, but not in the immediate future. That's for sure.
So what you're proposing today takes the place of what you had planned and received approval for previously?
Yeah, that's correct.
Okay. Connor Wright?
Yes, hello. Thank you, Mr. Chair, and good afternoon, committee.
Can we have your name?
As noted, absolutely. My name is Connor Wright. I am a planner with Zelenka Priamo. Our address is 20 Maud Street in Toronto, and I'm here on behalf of Choice Properties and Loblaw, who are the owner and leaseholder, respectively, of the property 2187 Lord Street. It's currently functioning as a no frills.
Okay, could you tell us?
Our comments.
Go ahead, sir.
Absolutely. Thank you. So our comments are primarily, as Mr. Fung did allude to, the operations that are currently existing with the loading dock. That diagram does show it well. As you can see, the no frills primarily fronts onto Bloor Street, but the only loading dock to the facility is through Kennedy Avenue, and that is directly across from the proposed play care. A few more details on the loading operations. There are about 10 to 15 deliveries per day, a variety of truck types and sizes. There is quite a bit of noise generated from this, including reverse alarms, as well as the inherent truck noise. If you go to the next page of this report, there is a more zoomed in diagram that shows that interface a little bit better, as well as some street view photos of the daycare. And then on the following page, what the loading dock looks like from the street. So we feel that this presents a potential significant compatibility issue, primarily relating to noise. So accordingly, it is really our submission to the committee, our request that this application would be deferred until such time as a noise compatibility study be performed and any recommendations be implemented. Based on the plans that were submitted, which I've seen, it looks like a privacy fence is being proposed along the frontage of the play care. However, it's unclear if this is intended to mitigate noise anyway. So we would anticipate, or we would request being able to see a noise compatibility study, and we'd be happy to provide all the information of our operations, facilitate that, and whatever the outcome of that study is, we would like to see that happen. So yeah, that's the extent of my comments. Thank you.
All right, so Mr. Wright, as I understand it, you are taking an unusual position here where usually we hear a neighbor come in and say, this is going to impact me, it's going to be too much noise, or or you're going to block the sunlight or whatever. What you're saying is we make too much noise and we're going to disturb the children. So this study that you're proposing, do you contemplate that it would sort of might result in a fence going up, with a fence that would dull the noise or reduce the noise?
Yeah, it wouldn't be for me to say. I think I would like to defer to a qualified noise expert on that matter. But it is a typical occurrence in various planning applications where there are existing uses that are lawful, and all the operations with no frills comply with applicable regulations and noise bylaw. However, there is still significant risk of complaints, even if the current owner is perhaps willing to accept that risk. Future owners of the property will inherit this existing condition, and it could lead to further complaints in the future.
So,
I'm sorry, I still can't understand the logic. What is the purpose of the noise report that you think that is bad, but then you feel so bad that it will make other people to, what do? They just take it or ask you to reduce your noise impact?
Yeah, I understand the confusion. I guess I should clarify my point. And my point would be that the applicant, upon deferral of this application, if the committee so chooses, they could make a motion to defer the application pending completion of a noise study. And the noise study may find that there is not a noise concern. And if they do find that there is a noise concern, perhaps they will implement or recommend mitigation measures, such as an acoustic fence to be constructed around the children's play area that would mitigate any concerns or risk of future complaints from the either the users of the daycare or the owners or potentially parents and so forth.
do you or your client have a proposal with respect to who would absorb the costs of the report and perhaps the cost of an acoustic wall?
It's our position that would tend to be the responsibility of the proponent, given that it's on their property. We would happily volunteer any information relating to the operations and help out in any way we can in that respect. But it wouldn't really be our responsibility to pay for the fence, to put it plainly.
Yes, Larry.
Thanks, Chair. Mr. Wright, in your introductory statement, I thought I heard you say that the current use, you used the term current use of this facility is for no frills. Are you aware of any applications to redevelop this property?
No, and apologies for that, for potentially confusing language. No, my understanding is there's no existing development application or plans to redevelop the no frills.
Okay, thank you.
Okay. Madison Chitato.
Hello?
Yes.
Hi. Sorry, I have a whimpering child on my lap if you hear anything. I am speaking in support of the project.
All right. Can we have your name and address, please?
Sure. My name is Madison Chiatow, and I live at 35 Hyde Park Avenue, which I know is recognized as not being directly around the property, but I'm a parent at the school. I have 3 children, one who's been through La Petite École, one who's in the program now, and one who will be in the program. I just want to speak in support of the project. It looks like this variance is very minor, especially in terms of, or like compared to the last application. There were more variances. This is less. And I don't know, I've never experienced any issues with the children with noise. We've been at that school for a while, and we've been amongst the trucks and the noise going to and from the school, and there's been no problem. I generally find that toddlers really enjoy trucks, so it's usually kind of a plus.
That's what I thought too.
Yeah, I just very much support some more full-day daycare spaces. It's very much needed, not only in the area, but in the city as a whole. This is also one of the only French language programs in the area, so full-day spaces of a French nature is also very welcomed, and I think I speak on a number of parents on that.
Have your children been in front in the area they're proposing as a play area when there's been trucks loading, unloading?
Yes, and it's always a fun time.
Okay, thank you. All right, Nicholas Singh.
Hello, yes, Nicholas Singh, can you hear me?
Yes.
Okay, thank you. Well, good afternoon, committee chair and members. My name is Nicholas Singh, and I'm representing the Swansea Area Ratepayers Association and Group. Just preliminarily, I submitted a supplementary document regarding process, so I'll leave that to you for your reference, and you can ask questions if you like. Focusing on the application before us, there was a question earlier about the previous permissions that were granted and how that's going to work with this one. I'm not clear on how that's going to work. Are they being revoked? Are they being given up? They were problematic to start with. And so how that plays out here affects our approach to this. To be perfectly honest, our view that the current application, does take that all into account, previous permissions. And so despite our current concern, the current application, we do prefer the current one and would be in support of the current application on condition that the previous approval for the side yard setback is voided and the previous plans are voided in favor of the current application and the plan submitted today. We would also like the front yard setback previously granted to apply only to the portion of the playground that is shown on the plans submitted for this application. If that isn't going to happen, then we are going to oppose the application because we feel that it is making a worse situation because you're adding current permission onto ones that we previously disagreed with. If we are to oppose in that situation where the previous permissions aren't revoked, then we would oppose on the following basis. We see no reason why a second playground should be approved where a variance has already been granted to accommodate one playground. And the problem with the new playground is that it is proposed for an area where it is expressly prohibited. The front yard setback previously granted did not involve a prohibited use. So we have a bit of a bait and switch situation here where the setback approval is being used for an unintended purpose. On this point, we're in agreement with the choice properties that there was a mismatch of land uses that was never contemplated when the front yard setback was previously approved. The next issue is setting aside of a specific use requirement. It's not the same as varying how much front yard you can occupy. The bylaw is intended to ban playgrounds in front yards in residential zones, and setting that aside does not maintain the intent or purpose of the ban. We submit that on the face of it, the variance does not maintain the intent and purpose of the bylaw or of the official plan. Similarly, varying a bylaw by setting it aside, there's two different things. If you set aside the ban, the bylaw is 100% eliminated, not minorly varied, but it's varied out of existence. This application seeks to occupy the entire front yard and the front yard setback that was previously granted for a different purpose right up to the property line with the use that is expressly prohibited. On the face of it, this is not minor and it fails to test for being minor. This is not about whether we like daycare, we do, so we can see that this is a desirable land use. However, it doesn't pass the 4 tests previously discussed, and obviously the dilemma for the association is that the new plans are an improvement over the old ones. As said, provided the previous approvals are modified and the old plans are made null and void in favor of the new plans. If the old plans and approvals are not modified, then the new application is just making things worse, and we have little reason to support it, and we submit that it does not pass the test for intent and purpose for being minor. Just as a comment, I'm not sure that this isn't all a bit moot. Could I get on screen section 45 of the Planning Act, please? We have the question of the powers of committee. We point out that the bylaw variance request before you today is asking for relief from Chapter 150, which lays out specific use regulations for a variety of permitted land uses from churches to marijuana.
You have 15 seconds, Mr. Singh. Would you please wrap up?
Sure. So a variety of facilities, including Tim Hortons style drive-throughs and of course day nurseries. As such, it's possible that some or all of the regulations fall under the criteria bylaws section of the Planning Act, section 45, subsection 101B and 1013. As a layperson, I'm not attesting to which way the special regulation should be treated, but I do recommend that the committee satisfy itself the special use regulations of Chapter 150 do not fall under 101 of Section 45, and that it has the power to proceed with this application.
All right, thank you.
That concludes my presentation. Thank you.
Mr. Fung?
Hi. So I can respond to both. I'll start with Loblaw's choice properties. There's 2 things about that. I mean, one, this is an existing urban daycare. Loading has been happening for a long time. Noise, we don't see noise as an issue. This is part of the condition. And secondly, anyone, as Ms. Chiatao mentioned, anyone who has children know that trucks are a spectacle. And I've spoken to the owner about this. It's actually a welcome thing. Like seeing some trucks, it's actually a really incredible thing for a child to see. So we're happy with the existing condition. We're not planning to change any of that. In terms of the Representative Nicholas, you know, it's a precarious property. We actually straddle 2 zones. So there's a commercial residential zone that's the north and a residential zone to the south. You know, like the proposal before you is simply to keep the existing building and build a front yard outdoor play area for 8 children. That's the one zoning thing we're looking for. We're not looking for 2 outdoor play areas. We're not looking to enhance the old layout. It's simply to keep the existing 24 children daycare and build a front yard outdoor play space so that we can provide full day daycare for the 24 children. It's a change in strategy from the original design completely. So those are my commentary on the 2 speakers.
All right, Mr. Fung, as I understand your comments originally, you're not proceeding with the application, the approval you had previously because it was too expensive, and you've changed and you now want the outdoor play area in the front yard instead of on the roof.
That's correct, yes.
And you're not going ahead with any aspect of the previous order?
No.
Okay, thank you. Yes.
Thank you.
Larry?
Thanks, Chair. A couple of questions. I was just looking at your site plan. So the outdoor play area that you are proposing is 30 feet from the face of the existing building, and that leaves, I'm confirming this, 24 feet from what would be the fence to the sidewalk?
24, we have, I think it's 18 foot 11 for the width of the outdoor play area. That's
18 feet wide, yeah, and it's 30 feet wide, and there's a figure on your site plan that says 24 feet 4 3/4 inches. So I assume, is that to the side? Maybe that's to the edge of the sidewalk, the other edge. And there's a fire hydrant. There's a fire hydrant in the front. So that area in front of what you're proposing for the play area presumably wouldn't be used for parking or drop off, would it?
Yeah, no, that's correct.
And you've got some existing hardscaping to remain, stroller parking. You know, even though you put up no parking signs, I'm pretty sure parents are gonna, if they see a spot in there, are gonna pop in there to drop their kid off. I think what I'm mostly concerned about in this application is the safety of the kids in the front. There's a reason why the bylaw doesn't allow playground areas fronting streets, and that is a safety concern. Tell us about what kind of a fence you're proposing to put around the play area.
Yeah, so it's meant to look like a white picket fence from an aesthetic point of view, but we were thinking of a steel reinforced bollard system. So it would protect from traffic disruption, potential like something bad.
So I don't mean to interrupt, but I get a little bit worried when I hear you say we're thinking about it.
Oh, sorry. No, yeah, that is the plan. That is the plan to construct something that can withstand impact.
Okay, and to the point that Loblaws officials are raising about noise, are you doing anything or contemplating anything for noise attenuation? Are you thinking about putting something along that area and along that fence that would reduce the sound?
No, I mean, the noise, it's going to travel. It's going to bounce around. We have nothing contemplated from a noise perspective.
What did it?
I'm the owner, and 80% of the city lot is outside the delivery house.
Yeah, no, I was just wondering, I'm sorry.
Sorry, I didn't mean to.
I don't know if I'm allowed to.
So if you wish to come up to the podium, introduce yourself, and you can speak right at the microphone there, just so everyone on WebEx and YouTube can hear you. Thank you.
Hi, everyone. I'm Jennifer Brown. I reside at 131 Colbeck Street, and I'm the property owner and the operator of the daycare. And I just wanted to add as a point as well that 80% of the time that we will be outside in the play area will be outside of the delivery times for choices.
Right. I mean, even planters or something like that, it just softens the noise a little bit. Maybe that's something that you could consider.
Happy to do that from an aesthetic point of view as well, and lots of gardening opportunities with the children too.
Great. Okay.
Can I add a comment?
Yes, yes.
Actually, when I look at the Google photos, there are two patios right at the Bloor Street and Kennedy. They actually have this metal, what do you call those, bollards? Bollards. And I think that is a good idea for safety. If we can suggest that they have those just at the perimeter of the play area.
Or something similar.
Something similar, yeah, that will be in addition to the fencing.
I mean, no one's anticipating that there's going to be an incident, but you have to anticipate that there might be an incident, right? Someone loses control of their vehicle. You really need something really solid there.
Happy to, yeah.
Yeah.
Okay. Okay.
May I say one last thing? I mean, in terms of the landscaping and planters, I mean, it would be my wish if that was not a condition. I mean, we could do it, but on our own accord for mix and noise. But my concern is making that a condition that forces us to have to put planters in the front.
What?
So planters wouldn't necessarily have to be on the inside of the play area. They could be on the outside of the play area.
on the city lands.
Oh, I guess, is that the property line? That is the property line.
That's correct,
Okay.
yes.
Can't
Yeah.
do that.
Well, I don't think we should be making it a condition.
No, it was just.
Some suggestion.
Yeah, it's just more of a suggestion. That,
Through you,
Yeah,
Mr.
okay.
Chair, we could do it as a for the
Yeah, that's
record,
totally
that it is strongly suggested
good idea.
for safety.
Okay.
Mm-hmm.
All right. Let us, okay, Mr. Fung, are you through?
Yes, I am.
Okay, thank you. Panel, do you have any further questions or comments or some advice for the owner? Or can we have a motion? Yim?
Oh, I can strongly recommend to have these metal bollards on the south side of the play area, because on the east side, they have a fire hydrant and have two huge metal thing there already.
I'd put it all the way around.
All the way, okay, we want it all the way around, that's the recommendation. And my other comment is that it is a very small daycare, and I think that it's very difficult to look for daycare spaces if you live in the city. I know a lot of people have difficulty, especially the French nursery. So to make it work, I think that it really, I can support this kind of small-scale nursery. Usually they are well-run, and the city really needs this kind of facility. So.
Okay, do we have a motion?
So my motion is to approve, but with a condition that safety, what do you call those?
So why don't we do, the fencing would include bollards or something.
That's a recommendation, not a condition.
Can we do, we can't do a condition on the fencing, the type of fencing? Can we? Yeah, I think we can do a condition on the type of fencing.
Okay.
And there are two pylons
But we do not know.
beside the fire.
We do not know
So you could do all you, if you.
the type.
want me- Yeah, so
You can.
my suggestion would be that fencing
Along.
around the perimeter of the proposed outdoor play area be constructed in a manner that includes
Metal,
safety bollards or
Reinforcement?
something of that nature.
okay.
Yeah, so it stops cars, basically.
And that would be on site.
Yes.
Yes.
Yeah, we can't put it on city property, right? Yep. So I hope that's something that you guys can do.
Yeah, I think so. And there are already two protecting the fire hydrant for that reason.
Yeah.
There are two on site already.
Yeah.
And I know this daycare, it is very well regarded in the community, so.
Thank you.
But again, never underestimate someone losing control. And you want to make sure you really protect the kids.
Yeah, I think it also, the south side is crucial because they will park and then they might.
Yeah.
Restate your motion again.
The motion is to approve with the condition that safety fence will be erected along with metal guards, metal bollards along the perimeter of the play area. Yeah.
Including the existing bollards. Because there are existing ones around the fire hydrant on the Tim Hortons side.
On the city property.
Yes, we cannot touch those.
No, yeah, okay, but you don't have to duplicate them on their own property.
No, well, again, it's your motion.
It's along, only because there's a little bit of a distance.
Yeah, my suggestion, if you look at the view, a car could lose control and come in on an angle. I just anticipate the worst case scenario, right? So it could come in on an angle around the fire hydrant, Chair.
Yeah.
I just think it's prudent to put them on the east side as well.
Okay.
Yes.
All right, seconder, Larry, all in favor? You have your approval, thank you.
Thank you. Merci.
Can someone contact Aaron and tell him that we're finished with that and he can come back on?
Yes, I'm here.
Oh, okay, good.
Bye.
Okay, number 30, 1344 Pape Avenue, In the purpose of this application to alter the existing one-story detached dwelling by constructing front and rear one-story additions, complete second and third-story additions with front and rear covered porches and front and rear decks on the second and third stories. The second and third stories will overhang the existing driveway on the north side lot line. Also, this dwelling will contain 4 dwelling units. Along with this application, we have material submitted by the applicant and a staff report from Urban Forestry. Agnes Skeen.
Hi, I'm Angus Skeen. I'm the architect and agent for the application.
Yes, can we have your address, please?
Yep. 142 Glendale Avenue, Toronto, M6R2T2.
Thank you. We're going to take this into committee. Do you have anything you want to say before we go into committee?
No, I'd be happy to answer any questions, but I'm fine. Thanks.
Thank you.
Chair, just a quick one. So it looked like your balconies are all, you have parapets around the balconies?
Yeah, I think they're parapet. Yeah.
So there shouldn't be an overlook concern from...
No, I don't think at all. And the planning normally would have chimed in if they felt there would be a concern.
Okay, thanks.
Okay, so do we have any further questions? Do we have a motion?
I think Aaron has one.
I can make a motion. I think it's very straightforward and is a very pleasant design, so I would like to support the motion to approve.
Yeah.
Maybe forestry condition.
Forestry condition number 2, Aaron.
Number 2, please, sorry.
Yeah, okay. Seconder? All in favor? You have your approval. Thank you, sir.
Thank you.
Okay. Number 31, 118 Havelock Street. Purpose of this application to alter the existing 2.5-story detached dwelling by constructing 2- and 3-story additions along the south side and west rear walls. This lot will be used for residential care home, a supportive housing purposes. With this application, we have material submitted by the applicant. We have a staff report from Urban Forestry. We have correspondence and support from various addresses, including Havelock, Rusholme, Moutray, some no addresses, Gladstone, Bayview, and Monterey. More no addresses provided than provided. All right, concern from 126 Havelock Street and opposition from 123 Havelock and 190 Rusholme, and from 119 Havelock, 94 Dewson, 122 Havelock, 399 Markham Street, 114 Havelock, 127 Havelock, 121 Havelock, 107 Dewson, and a 15-signature petition in opposition from properties on Havelock, Dewson, Dover Court, and Rusholme. Judah Mulala.
Judah, you've been unmuted.
Thank you. Good afternoon. Good afternoon, Chair and members of committee. It's actually Judah Malalu. Thank you for your time. And at this point, we would like to request that the hearing be deferred for further consultations with planning and to do a bit more community outreach, because there seems to be quite a bit of misunderstanding as to the intent of the project.
Okay. All right, so Peter Zimmerman. you have Mr. Zimmerman on the line?
Yes, my name is Peter Zimmerman. I live at 171 Havelock Street. In light of the applicant's request for deferral, I'm going to not provide my comments, which would have been in strong support of this application at this time.
But are you in favor of a deferral?
I'm supportive of the applicant's position on this.
All right, thank you very much, sir. Danica Miller.
I am supportive in principle of.
What is your name, sir, and your address?
My name is the same name that you gave, Danica Miller. My address is 20 Bright Street, Toronto, Ontario.
Okay, are you in favor of a deferral?
As I was saying, I am in favor of a deferral if that is what the applicant desires.
Yes.
I would like to underscore that.
Yes, but
further
that's the only issue we're dealing with right now, sir. Thank you very much. Katie Longo.
Address is 166 Delaware Avenue, and I take no position on the subject of a deferral, other than to express skepticism that outreach would change people's minds.
All right, you are Katie Longo?
That's correct.
Okay, we didn't hear that part of your, thank you very much. Beth Mills?
Mills. I live at 153 Havelock Street.
Are you Beth Mills?
I am.
Okay. Are you in favor of a deferment?
Yes, I am,
Right.
on condition that it actually is outreach and consultation.
Well, that's what the applicant has said, and we're going to hold them to it. So thank you very much. Paul
Thank you.
Little?
Havelock. I'm okay with deferment.
All right,
Again, as long
you're
as
Paul
it
Little?
involves.
Yes, sir. You're Paul Little?
I am Paul Little at 65 Havelock.
All right, for some reason, we're not getting the name. So you're in favor of a deferment?
In favor of a deferment with proper consultation to the neighbors.
All right, thank you.
Not just information.
All right, thank you. Evelyn Shore?
I'm Evelyn Shore, 114 Havelock, right next door. I'm in favor of deferral if, again, we're actually consulted and not just, told what's happening.
All right, thank you. Matthew Taj?
Through you, Mr. Chair, we've tried to contact Matthew, but I don't believe we've been able to connect him.
Okay. Karen Bernhard Walther?
Yes, hello, my name is Karen Bernhard Walter. Can you hear my name?
Yes, we can.
Okay, I reside at 143 Havelock Street.
All right.
This is a very active
Are you in
community,
favor of
and
are you in favor of deferment?
I am in favor of a deferment as long as it's not a tactic to just, have this hearing another day when the community is not as present.
Yes, well, I think we should ascribe good faith to the applicant as a
Absolutely.
default position. Thank you. Is Mr. Kameny on the line? He said he's observing, but he also says he's in opposition, so I take it he didn't want to speak. So he's not on the line? Okay, thank you. Okay, Mr. Mulala, I don't think we need to hear from you again.
Through you, Mr. Chair, we do have others on the next page.
Oh, I'm sorry.
Yeah, no, it's okay.
Oh, my God.
So
Where did you-
for the next people that we're calling on, we just want to know if you're in favor of the deferral or not in favor of the deferral. So we'll go with Naomi Lowith.
Yeah.
I have 9 Havelock, and I'm in favor of the deferral.
Thank you. Andrea Breen.
Through you, Mr. Chair, we haven't been able to connect with Andrea or Tiago.
Tiago Kurtz, you can't get a hold of either. Emma Paisley.
Emma, you've been unmuted.
Oh, I am in agreement with the deferral. I'm at 69 Havelock.
Thank you. Teresa and Amelia Turano.
We haven't been able to connect with Teresa or Amelia.
Okay, Emily Sunshine.
Also unable to connect with Emily Sunshine.
Okay. Peter Spiliotopoulos.
Peter, you've been unmuted.
I'm okay with the deferral. That's fine.
Thank you. Jesse Boyer.
Jesse,
What is
you've
the
been
purpose
unmuted.
of the deferral?
Hello.
Hi, it's Jesse Boyer from 248 Havelock Street. I'm just wondering what the purpose of the deferral is.
To consult with the opposition neighbors.
Neighbors, okay, I'm in favor of that.
Thank you. Robert Alonso.
Robert Alonso, there may be issues with your microphone, but we have you unmuted.
Okay.
Okay.
I'll go on to the next person. Okay, can we cut out the echo? Okay. Okay, Alan Ramsey.
Alan, you've been unmuted.
Hello, it's Alan Ramsey.
Are you in favor of the deferral? Mr. Ramsey, are you in favor of a deferral? Did we lose him?
Hello, it's Alan Ramsey.
Sorry, through you. Alan, can you hear us? Okay, it appears that the hearing, like this room is muted.
Alan, you've been unmuted.
Hello, it's Alan Ramsey.
No, they can't hear us.
Are you able to hear us? Oh, I guess not.
No.
Hello?
Okay, can you just put up the lid?
Yes, it's Alan Ramsey.
He can't hear us.
How did we?
Yes, I was muted.
Alan, are you able to hear us? See, we're getting the feedback.
Hello, it's Alan Ramsey.
Okay. Okay. Mr. Ramsey, can you hear us now?
Yes, I can. Thank
Okay.
you very much.
Are you in favor of a deferral?
Through you, Mr.
Yes,
Chair.
If I could just clarify one thing. So I'm a planning consultant, and I'm acting on behalf of several residents on Havelock, Rusholme, and Dewson Street, and I can give you those addresses if you wish. But I am acting for 10 families in the vicinity of the subject lands, and we would be happy for a deferral.
Thank you. Okay, were you able to get a hold of Mr. Alonso?
Robert, you've been unmuted.
Hello?
Yes.
Hello? This is Robert Alonso.
Yes, are you in favor of the
I am in
deferrals?
favor of the deferral.
Thank you very much. Okay.
Yes, sir. Yes, sir.
Yeah. Do we have a motion for a deferral? Yim.
Okay, I make a motion to defer this case so that the applicant can consult the neighbors and discuss it with the planning.
We have a seconder.
Hey, Carl.
All in favor? Thank you. All right, you have a deferral, sir.
Thank you.
Okay. Number 30, Parkfield Avenue. The purpose of the application to alter the existing two-story semi-detached dwelling by constructing a complete third-story addition with a rear terrace and a rear two-story addition. With this application, we have material submitted by the applicant. Opposition from 200 Alton Avenue and a 5-signature petition in opposition from owners or occupants of properties on Alton Avenue. Shahid Nanavati.
And the address is 1304 Woodbine Avenue, Unit 1.
All right.
Thank you.
Could we just have your name? We didn't hear your name.
Oh, my name is Shahid Nanavati.
Okay, thank you. We're going to need a brief presentation because there is opposition.
Sure. Well, may I request that the supporting material that was sent on Saturday should be presented or put up over there, please? The other one that was given on the 5th of September? Yes, thank you. Yeah. So I would go directly onto the variances that are requested. Number one, we have a variance for the landscape, which is the first one, and which is also contention by the people living on Alton Avenue. This particular landscaping we have inherited from the previous owners, and that is at 10.1%. However, with the help of the community planner, we have increased this landscape to 26.23%, and we have agreed to that and have submitted the new plan for it. Okay? So we request the committee to consider our situation, and all the other stuff which is hardscape is basically impermeable interlock stones and will not have any water collection over there. The water would be absorbed immediately by the ground. A second, the variance that we are looking at is for the height over there. I would like to bring to the attention of the committee, through you, the chair, that we are increasing the height of the building by just 0.56 meters than it is permitted by the zoning. So with 0.56 meters, we beyond the zoning, that's why we are getting this variance into. Now, the internal height of the house, we are just giving it basic 8 feet internal height. Now, we had gone to various architects, various planners, and almost for 6 to 8 months we consulted, and none of the planners were advising us to go and extend it at the back, because we have a very small car park at the back, and maximum we can extend is 8 to 10 feet of the building at the back. So our property is very stringent over there. So the only alternate we had was to go up. So what we did is went up onto the 3rd floor, taking care that the building has all the good features at the front, the cityscape, the streetscapes. And at the back, what we've done is not extended the third floor fully so that it would not have any shadows or minimal amount of shadows, if there would be, on the neighboring property. So we've taken care of that, and with decency involved, with the community planner, we put a privacy fence on the balcony that comes up over there. I will give an understanding on the next page that we are not casting any shadows onto the neighbors, and we are not becoming an issue to claustrophobize their backyard. So may I go to the next page? So that big arrow to the right is showing our house over there. And the Alton Avenue homes are pretty much far away. 200 Alton Avenue, who has lodged a complaint and saying that we will be causing issues for his vegetation, has a massive shed touching our property line. And if you look at the white patch over there, that's a massive shed that the property 200 Alton has. And if there is any shadow, it will fall on that shed, but not affect the backyard. And in the same way, the others as well, their properties are very far away, their homes are very far away, and the shadow is going to be minimal because we are not going and extending whole backyard of the building into an extension, or neither are we going very high. So I request and kindly tell the Alton people also to understand where we are coming from. So we have got no other alternative. That is why we are doing this. If we go to the next variance, so which will give an idea that we are not overshadowing their backyards. I've given two season sun diagrams over there, and with the references of how they've been brought over here. So I've given a date over there. If you look at on top, this is the winter diagram. And during winter, if you look, the sun is starting from Alton Avenue in the morning, and it is traveling towards our house in the afternoon. And then in the afternoon, there may be some shade in the backyard. All the morning, all the time in the morning, up to late afternoon, the sun is over Alton Avenue homes. So there's very little chance of their vegetation being affected because of the construction over here. If you go to the next page, it will show you the summer diagram.
Mr. Navavati, your time is up. So is it?
I'll just take 10 seconds and wrap up.
Okay.
Okay. If you go to the next page, it shows a similar one with the summer diagram, and it shows that the same features are there with the sun coming back late in the evening in summer to lighten up Alton Avenue. With this request, I ask the committee to understand that we, at this particular house, we have got 3 kids, husband and wife, and a grandfather who takes care of this place. And we have got, as per the FSI, we just have 1092 square feet, which is less than an apartment building. So please consider in giving us the FSI and the other variances. Thank you so much.
Thank you. Any questions, panel?
Through you, Mr. Chair. So we have David and Sharon. Sharon is remote. David is here in person. They will be sharing the 5 minutes.
My wife is much more eloquent than I, so she'll give her the bulk of the time, and if there's anything missed.
Okay, so
Okay.
she's got 3 minutes and you 2. All right,
Sure.
go ahead,
Okay.
Ms. Gunn. Ms. Gunn, are you there? You got her?
Sharon, you've been unmuted.
Yes, I've been now unmuted. Can you hear me?
Yes, we can.
My name is Sharon Gunn. Address is 200 Alton Avenue, and I'm speaking in opposition.
Go ahead.
Our concern is about the first 3 variances for ourselves and for our neighbors. We are speaking on behalf of ourselves and our neighbors at 198. We have a few images to be able to give the perspective from our side, which were submitted. We feel that the first 3 of the 5 variances will not be minor. They will have visually a daily impact on at least 2 other households, potentially set the stage to change the nature of the buildings in the area. And because of this, it does not seem to keep with the intent of the city plan and the zoning bylaws that the height, the density of the area should prevail. We feel that, and you'll see through the images that we did submit with a Photoshop version to show where the wall will take place, or where it will be situated, that we'll be losing, as they mentioned, sunlight, but it is also about the view that we have from behind our building. We have not included a second floor view, but that will be directly into a window on our second floor. It also means that with the backyard patio, that it will be looking right into our yard. And then the second and third photos that we have in here, the third and fourth photos show the property that was just purchased, 198 Alton. They have just moved in this past week and so have had no opportunity really to absorb the fact that the area that they purchased is now going to look drastically different from their yard when this 3-story building is added. And I will add, based on the last comment, that they are concerned about being able to add more family members, larger space, that we are a neighborhood where many people, these homes, these small 2-story attached homes, as a starter home. And unfortunately, they're very expensive for a starter home, but they are a starter home. Many families, once they have 2 children or multiple family members, then move out of the neighborhood. Otherwise, we're concerned, and this is where the other neighbor signatures are in place, are concerned that this will become the norm, that everyone then extends their houses, covers the green space in the back, and that homes become a multi-generational, multifunctional home that is also a rental space as well. I'm all for rentals, but I feel like this would change the structure of the neighborhood. At this point in time, if David would like to continue, I will hand that over to him.
All right, Mr. Gunn, you got 2 minutes and 5 seconds.
Not too much to add. I didn't quite catch everything the architect of Norseman was saying. His accent was a little hard, but he was talking about the impact of the shadows, which is something we brought up. I would dispute him saying that it's going to be very little or nothing for sure, based on what I can see. It's not going to be all day, obviously, and it also depends. As we stated in our thing, we have a garden in our backyard, and we grow food in there. It's not just regular vegetation. And in the spring, especially there to the south of us, the sun will be coming over the 3rd floor. I have no idea. I'm guessing to me, it seems like it would be an hour a day less. And yes, we could probably manage still somewhat, but it's going to be compromised. I'll give Sharon maybe the last thing. If the purpose of the building is because of extended family members or family growing up, I would slightly dispute that looking at his schematics. I'm just speculating, but look, they're extending the kitchen, they're extending the master bedroom, they're putting something on the 2nd floor called the Family Heritage Armoire. So I'm not exactly sure the motives of why this building is taking place in the first place. I think that's it. Sharon, you still have 45 seconds there.
Thank you. I believe that is everything from both of us. I would end on the fact that I really do not believe it would be minor, but I'm happy to answer any questions that would be relevant for us.
All right, thank you. Okay, so there's no more opposition on the next page. Is that right? Okay, let's go back to Mr. Navavati.
Can I just ask a
Oh, yes, go
quick
ahead.
question, if you might? So I'm just looking, this is your photo from your backyard, is it? No.
That's 198.
This is our, sorry,
That's the
this
next
is
door.
our neighbor.
That's ours.
98.
Well, that's yours. So it looks like, I'm in the laneway looking, there's a tree, it looks like in between the proposed house here.
Yep,
And is it you or your neighbor's tree?
that's the neighbor's tree to the south.
So that, that will, I mean, that tree will block your view, maybe not of the extension, but of the third story, will it?
I think a little, I think.
Yeah, so it will hide the
Well,
third story.
It's not a huge tree. It doesn't go, like it goes about 2 stories high, I think, maybe a little more than that now.
Yeah, okay. But it doesn't extend, it doesn't look like, from your rendering here, it doesn't look like it extends to the addition. And your concern, your and your wife's concern, it would appear looking from that drawing that people can stand and look into your backyard.
Yeah, I mean, it's not, I tried to be as accurate as I could based on distance, but I'm trying to give an impression of loss of privacy. Yeah,
Right.
It's part of the reason we moved into that house and had a little spot of privacy in the backyard. And
Right.
We eat dinner on our back deck every well, a lot. Like we have a small house, so we spend a lot of time back there.
Yeah, okay, thanks.
Okay, any further questions? All right, do we have a motion or comments?
Yes,
Kim?
well, I think the soft landscaping, he increased it 26.23%, but I think we need the square footage too, the area.
Sorry, Chair, is the agent coming back to respond to these guys?
Oh, yeah,
Yep.
I think I got waylaid.
Yes, thank you.
Mr.
Thank you. I was just
Nanavati.
waiting to be on. Yeah, thank you, sir. Yes, I have given, if you look at the second, the set of plans, which I've given, the revised ones, that has got the new area noted in it.
I think it's 13.3.
Yes, that's the one. So that is our backyard. Yes, please go to that picture itself. That'll give you an idea. Go to that, yes. So that picture gives you an idea that the cross area that is shown over there, you're going to make it into a landscape. And the rest of the area that you have accommodates the car park as well as a strip to walk on, basically. So it's all the interlock permeable, and that will help as such. So I've given on the next page, the area chart is given with the new landscape area.
Yeah, I'm just trying to say the new area is 13.3, right, square meter?
Yes, it has been, yes, ma'am.
Yeah, okay.
Okay. You have anything further to say, Mr. Nanavati?
Yes, yeah, you can see the privacy fence over there. So the concern which the neighbor has, that we will be looking into their backyard while they're having dinner, will be taken care of. And we are not extending, we're just extending 8 feet out over there into the backyard. We don't have any space over there. So that's why we are going up. We have no choice over here. And this family is having 3 young children of 5 years, 9 years, and 11 years, and a husband and wife, and a grandfather who's taking care of them during the day. So now looking at that, and if we have to request for a variance for FSI, because the permitted FSI is only 1092. Although the neighbor has said that we have extended it, we have just extended the lower portion by 8 feet. So on the ground floor and the second floor, the building has been extended by only 8 feet. Third floor, we've not extended the building. So we've done our best to take care of the neighborhood over there. And there are precedences for the FSI in that area. If that is, we've got a lot of third floors being added in that region. If the committee would like to go on Google and check 45 Alton Avenue, it has got a third floor. 108 Leslie, which is also noted over here, all of them are noted here. 108 Leslie Street, that has been given a third floor. 26 Modern Avenue has been given, and other two areas as well, that is Dundas and Queen. So I really request to understand our situation. We have no choice. That is why we are doing this.
I get a rebuttal to that?
No. Okay, do we have any?
One further question, if I might, Chair.
Yes, sir.
I think I read somewhere where you indicated that you are increasing your soft landscaping by removing some of the pavers.
Yes, that red square that you see, rectangle, you're removing that.
Yeah, no, I get that. I thought I read somewhere, either on your plans or in your material, that the remaining paved area is permeable pavers.
Yes, sir. All this is interlocked stone with openings or with gaps in the middle, and all the water can percolate below into the ground.
Yeah, I'm not sure I'd agree with that. Your assertion that those pavers are permeable. I think just looking at them in close up, they are standard pavers.
Well, what we could do is,
unless you know for sure whether your client specifically installed permeable pavers or not.
right, we inherited this backyard. So what we can do is we can increase the spacing between the blocks and have this area totally permeable. So if at all there is very little gap between the stones, we will increase the gap and make them permeable. The total area can be made water absorbent.
Yeah, that's good. So you would basically lift those pavers and reinstall them.
Yes.
Okay.
Yes, sir, with a gap in between. And I wouldn't mind to have that condition, no problem.
Okay. All right. Do we have any further comments or questions? Do we have a motion?
We don't get a second. Anything else to say?
I'll start. First of all, thank you for coming down. I really appreciate it. And we understand your concern. But our experience is that what is being proposed here really isn't that egregious in terms of the impact. I appreciate you won't agree with that. But this is a development where 3 stories are allowed in the city now. The proposal is set back in the front, and the rear portion is only 2 stories. Planning has asked us to put a condition for privacy screening over the balcony in the rear so that it reduces the overlook on your property.
It's not 2 stories, it's 3. He goes,
No, I get that. It is 3 stories. Well, it's 3 it has a terrace, yes.
a little extra.
But notwithstanding that, that is kind of permitted.
Precedents.
No, I appreciate it. I'm not going to get into it. You're not really allowed to do that. The variances before us really, in some, I find overall relatively minor. The concern mostly that I had initially was the soft landscaping. The agent and the client and his client have improved that, and I was heartened to hear that they would be prepared to lift the existing pavers in the rear and install permeable pavers or the equivalent. I think that helps an awful lot with respect to dealing with some of the water issues. But again, I don't find the proposal and the variances being requested to be significant, and there are other 3 stories in the neighborhood, so I think it's a supportable application.
I just wanted to make a comment. Mrs. Gunn said that these are starter homes, and when people feel they have children, etc., they move. Well, that's no longer possible in many cases. as I think you said yourself, these are starter homes, but they're expensive. Well, moving up is sometimes too much of a gap, a financial gap for people these days. And so we get a lot of people who prefer to renovate their existing premises because they can't afford to move. I think that's going to become the case. And this isn't going to set a precedent. It's people's financial wherewithal that's going to set the precedent. They're not going to be able to move. So, so do we have
I'm going to move a motion, Chair, if that's okay. Yim, did you want to say something?
Yeah, actually, I agree mostly what you both said, but I also noticed that the privacy issues that is they put the privacy screen that and then also with the height is actually the other property on Elton Street, they have really deep backyards. I do not think that it will the overlook will be a problem with the privacy screen.
Okay.
So yeah.
So I'll move approval of this application, subject to, I think what we'll do is tie it to plans, because I think the revised plans included the privacy screening. And a condition that the rear yard be replaced with permeable pavers.
Yeah, and yeah,
The amended application, pardon me.
So Larry, I'm not sure that the applicant, we may want to ask him, but I'm not sure. He says he's going to put permeable pavings in. I think he says he's going to relay the stones and make the gap wider so it'd be more permeable.
It's almost the equivalent, yeah. So maybe what we'll do is replace with permeable or equivalent. Would that be good for you?
Well, I think he intends to relay it to make it more permeable.
Okay.
I think if you say permeable, they're going to stick them. He's going to have to replace the stones.
Okay. Then the condition would be that the existing pavers in the rear yard be improved to allow permeability.
Yep.
That sound right?
Yeah, improve, yeah.
Does that work for you guys?
I'll second it.
All right. All in favor? Okay. You have your approval, sir. Thank you.
Thank you very much, sir. Thank you.
Number 33, 5 Indian Valley Crescent. Purpose of the application to alter the existing two-story detached dwelling by constructing front and rear two-story additions, a partial third-story addition with a front covered porch, a front second-story patio, a side east integral garage, and rear patios on the ground, second and third stories. With this application, we have material submitted by the applicant, a report from Ravine and Natural Features Protection, support, 5 form letters in support, in opposition from properties on Parkside and Indian Valley Crescent. Mr. Peterson.
Hello, my name is David Peterson. I'm the architect for the property, 90 South Queensdale. I have my address.
Could you speak closer to the microphone, please?
I'll speak up. David Peterson. I'm the architect here with the property, 90 South Kingsway is my address.
Okay, can we have a presentation because there is some opposition?
Certainly. If you can load the plans, I'll take us through that. So let's start here. So the first thing I'll describe is that is the massing for the building. When we see the building from the street, it appears to be very much like a two-story building because the third floor is set back significantly. Moving to the next drawing, the site plan. So when we look at the site plan, part of what we see is that there is a mutual drive on the east side of the property.
I'm sorry, I'm having difficulty. He sounds muffled. I'm having difficulty understanding.
Oh, Mr. Peterson, we need you to speak up.
Okay, I'm sorry. How is my volume now?
It's better.
It's a little better.
Okay. So on the east side of the property is a mutual drive. We intend to maintain the grading on that mutual drive, continue to use it as it has been. I'll make note of the existing mutual drive is 2.7 meters wide, which is approximately 9 feet, which would allow for a kind of single drive access into what is the parking garage off of that laneway. The next plan, the basement floor plan. What you see here are the existing, those dark colored lines are the existing foundations for the east and west sides. So part of being able to maintain the grades along the mutual drive is by our strategy of keeping that foundation wall along that side, the foundation wall along the west side, where there is a retaining wall. That wall also remains and allows us to not do any shoring along that side. Part of what you see there is at the back of the building is a family room that's added to the building, and that remains at grade. Part of what you'll see in Arbor's report is that there is that addition impacts roots related to the neighboring trees. We've met with forestry to speak about a strategy for how we would do our best to limit our injury to those trees. And the strategy essentially is to first do a root investigation with the city present, forestry present, and then devise a kind of grade beam solution to avoid roots in that area. We also have, when we look at where the cars are parking along that laneway, that's the existing location for where the car is currently, and we're looking to maintain that. As we move through the plans here, you'll see that that family room is actually at grade, and there's a patio that is at the rear. And the building's total length, which was previously approved and not previously tied to plans, and we're not looking for further variance related to that length, but it only exists, so we go to the next plan. Even here, we see that the building is not that total length, it's something smaller, where we've got a patio, and that patio is also screened east and west, so that views are directed towards the backyard entirely. I'll move it along to the third floor, where we see that the third floor is set back both north and south, and is a smaller footprint where the master bedroom is. If we go to the building section, 400, I believe, it'll give us a really, we can see that part of what's occurring is that the existing basement remains, and that the family room is an addition without basement. And essentially, to manage the kind of sloping nature of this site, the building steps inside so that it's possible to be on that initial ground floor and then move somewhat down into a family room and then down further as we go to the patio and then back into the existing grade.
All right, Mr. Peterson, you have 22 seconds.
I'll stop there and take any questions if there are any.
All right, Larry.
Thank you for your time.
I'm going to ask the obvious one. I think some of us were on this panel when this application was heard a couple of years ago, and I recall it being quite controversial. But fundamentally, what's changed? What's different? You've asked for more FSI than you were approved last time. So can you be, like, just bottom line, what has changed and what is different from what was approved previously?
The building is, much of it stays the same. Part of what we've done is modify how the building works internally. It's as long as previously contemplated. It's as tall as previously contemplated. And we've added spaces where we include solar panels off of that third floor roof. So it's really a reconfiguration internally that's the kind of major change.
But you've added FSI somewhere. Can you tell us where the FSI is?
I suspect it's in the rear addition.
Sorry, you suspect?
Well, I'm not familiar with I wasn't the architect for the previous iteration.
Well, it's pretty important to us to understand how you're varying from the previous approval that you received. So that's what I'm really trying to get at. If you've added floor space, you need to help us understand what that is and where it is.
Well, the existing building remains the same. So we've removed any voids that previously existed inside of the building and added more floor space that way. And the addition at the back is in that family room is where we've added some more space.
I'm sorry, I didn't quite catch that. You restate that, please?
We've removed any interior voids, so that added floor space. And we've added more towards in the family room, was previously on the second floor. Yeah.
Just jump in and ask a quick question.
Yeah, maybe I'm not understanding, but.
Yeah, so I guess I can try to rephrase the question is, the numbers in front of us on this variance is the number comparing to, well, the drawings that you have submitted is the comparison of what is existing to what you're proposing, or you're comparing it to what has been approved before and what you're proposing now. I think that's something we would like to know.
Well, what we're proposing is a total variance. So when we're looking for what is 411 square meters is the current proposal. So you'll see that the drawings speaking to over and above what is allowed.
Right, so the last architect who got the approval had a different design.
That's right.
And you took over the project, changed the program, changed the concept, and come up with a new design. And in front of us is a new design with a new set of variances. Am I correct?
That's right. And
you're not building on top of from the last. So the last architect didn't actually build the project.
No, that's right.
Basically just build from existing, meaning what had been approved last time is no longer being carried forward to this application. Am I right?
That's right. I mean, we're seeking we're seeking one new variance, and we're applying previously approved variance. Part of what I can do to help, you can see in this drawing, the line of the existing building at the front toward the street. And those triangle pieces are additions to what was previously shown. The previous proposal maintained the front setback. We're adding a little bit more GFA there, both on the ground floor and on the second floor.
Aaron, are you done?
Yes, I'm done. I think I get what he's saying. Basically, the last approved design was cancelled, and he's the new architect coming in with a new design, with a new set of variances. So we don't have to worry about what has been approved last time.
With one exception, the only question I would have, and maybe we're going to hear some people, I think, that have some concerns, but you know, we were granted a height variance, and the height variance was based on a design. And if that design is changed, is the height variance the same impact now as it was before? Like, for example, is the height carried deeper in the lot now than the height was when it was originally approved? That's the only thing that's working through my mind.
Well, did they, so Mr. Peterson, did you incorporate any of the approvals from the previous decision? Or is this brand new and you've eliminated all the variances except for the one relating to floor space index?
No, we are anticipating making use of the previous variances, including its height, the building depth, and the size of a platform. So I had submitted as a part of my documentation previously approved variances that were a part of the proposal. So part of what we can see is that in that previously approved design, that it is that 3-story portion comes much closer to the street. Our 3rd story is set back significantly more than that, so that the building, as the illustration demonstrates, it really appears to be a 2-story building towards the street.
But what is the 3rd story in the rear? Does it go back further than what was the original proposal?
I can't speak with detail to the original proposal.
Okay, thank you. Maybe.
Larry, I just want to make a comment.
Can I add my comment? Aaron, I do not think what you said is correct, because when I look at the previous application, they actually have 6 variances. They have used the height, the depth, and I think the sidewall variances. Actually, they have included all those variances.
That's what I'm saying, yes.
Yeah.
That's what I'm saying. They did include it at the height variances and everything.
True.
So when the zoning examiner was looking at giving this notice, they have incorporated those approved notice, yes. So we're adding one. Yeah, so I think what Larry was saying was correct at the beginning.
Yeah, so maybe we'll hear from the opposition, because they may raise some of these issues.
Okay. Are you on your... No, we have the in-person person first. You're Stephen Alicakos?
Yes, my name is Stephen Alicakos. I live at 427 Parkside Drive.
Okay, go ahead.
My wife and I are the owner of the property immediately adjacent to 5 Indian Valley Crescent. And is it possible to get one of the images up that show the side west face or not? I'm not sure who's controlling those images. That one right there. This proposal is quite a bit different than the original one. And I'd just like to speak to that, because I believe that what we're objecting to are variances that are not minor in relation to the surrounding properties. If the applicant receives approval to proceed as proposed, my family's backyard will sit immediately adjacent to a massive structure, and our existing deck and garden will be below and shadowed by a towering 40-foot tall wall and 3 new elevated decks compared to the original proposal, all overlooking our private space at elevations far above what the existing bylaws allow. We found that the bylaws allow for single-family homes to rise up to 10 meters or 32.8 feet. Please excuse me, I still speak in feet. And I found that the applicant's submitted plans have failed to identify to the committee with their variance request that the proposed extension to the existing home is to be placed on lands that drop down from street level, and that the actual height of the extended structure will rise up to almost 40 feet. Almost 10 feet higher than allowed, all of which would fall just 23 inches from our home's backyard. I don't believe this can be looked at as a minor variance when it affects a neighbor this dramatically. The applicants propose to extend our out past their current house's depth and run this 40-foot tall wall and raise 6-foot high back deck across almost the entire width of our backyard, something that doesn't exist at this time. And I'm suggesting that this is incompatible with the adjacent homes and our current neighborhood's form and should not be permitted as proposed. The length of this giant 40-foot high structure is proposed to be 21 feet longer or deeper than the bylaws allow, not including the proposed extended raised deck that's positioned at the back of the property and the back of this extension. We're asking the applicant to respect the bylaws created to retain the built forms of this neighborhood and to ensure that there isn't such an intrusion on our privacy because if this is approved, we will not only lose that, but a substantial amount of natural sunlight for our backyards, garden, and trees, along with the airflow that we now enjoy from the spacing that we currently have. All of this to be lost if you approve this massive white wall. Both the applicant and our family now enjoy a dense green screening of mature trees, providing privacy between our shared properties. If the application as written is approved, we'll lose this, and I'm fearful of what this will do to our property's value. The applicant's own arborist report has acknowledged that 5 of the 30 to 50 foot tall trees on our property adjacent to the proposed white wall will either be injured or destroyed when and if this structure is built. And even the city's own forestry experts have acknowledged that there is a strong likelihood of us losing our trees. If not during the construction and necessary pruning on the applicant's side to make room for this massive extension, then likely after, when our property is shaded by their proposed 40-foot wall. We further object to the committee approving the 3 proposed decks or new balconies that are positioned at the rear of the applicant's structure on each level, all of which have clear, purposefully designed overviews of our backyard and home. In addition to the 2 upper floor decks, the lowest deck is proposed to extend 16 feet from the rear of the new massive structure and is proposed to be built at a level almost 6 feet above our backyard, which is immediately above where our existing back deck sits at ground level. If built, the applicant will then have 3 observation decks to view down into and over our backyard, once again just 23 inches away from the property line, 0.7 meters. This request for these variances run against what we believe is the purpose of the zoning bylaw, which prescribes these setbacks and height restrictions for massing, decks, and balconies that overlook other people's private areas. And we feel that any approval to amend our protections and property rights should not be given without consideration to what they will ultimately do to the surrounding property's privacy and property values, and what the massive size of this high and deep structure will set as a precedence in our neighborhood. In addition, we object to this structure proposed cladding in white,
You have 9 seconds, sir.
causing our view from every window at the back of our home to go from a current lush green to a blank 40-foot high wall of white, similar to a drive-in movie theater screen. Just one short minute, please. This design, which does not contemplate our views or the fact that this is set out of place in our neighborhood of brown and red brick. All the requests by the applicant for this single-family home have not taken into account our views or those of the immediate neighbors, which have been demonstrated by their unwillingness to include the surrounding neighbors in any discussions prior to the meeting of this committee. So I ask the committee, before it makes its decision, to agree to relook at the applicant's plans, as they are a clear break from the scale of other homes around them and the bylaws as written, and believe that the committee will find that approving them is inappropriate and should not be allowed to proceed as proposed. Thank you.
Sir, were you at the previous hearing?
I was not, due to a family health issue with my parents.
Okay, so Aaron, as I understand from what we've been discussing, all those variances were approved. The only thing we're asking to do today is approve a floor space index.
You're right. But then, look, considering what Larry have mentioned, those approved variances were tied to the plans at with a certain level. So we might have to look at this application in a different way. And even if we're just looking at floor index, it has implication of the overall massing. Not that I'm opposing the design, I'm just speaking it in a fair way that I think there's implication for this floor index and the new design, the implication of the new design towards the neighborhood.
So, but now, does a new design, in your opinion, nullify the previous decision, or is it based on variances that the new design still complies with the old variances that were approved?
I think that's how I'm looking at it now. The way, and I think the applicant had mentioned earlier that I think he was trying to explain that the void or so-called the empty floor space or the atrium space, floor openings has been filled up, and that's why there's a floor space index increase. And it doesn't really affect the exterior. I think that's how we can go back to the applicant and confirm if that's what you were saying, but based on my understanding.
I think that's the
That's what
point
he
of
was trying to
contention, right? I think that's the point of contention. Is there any change in the exterior? Like, for example, does the third floor, it sounds like we're in committee here, Chair. I don't know whether we should be doing this.
Well, I'm trying to get it straight. I'm trying to figure out what we're talking about.
But the uncertainty in my mind is, particularly in the rear of the building, is the height different now because they now have an approval to go to 11.5 meters? Is the height profile in the rear different because it's a new drawing than what was approved, the drawings that we looked at when we approved it the first time? That's what I don't know, and I didn't hear the architect being able to explain that.
Were the plans attached and to be?
Yeah, the height is actually lowered, and I should let the applicant to defend for himself.
Okay, yes, Jim.
Yeah, my experience, this is the first time actually when they have not built a first proposal, and then they included all the variances, and then when they propose a second application, they ignore the fact that the existing building is not like that at all. I think that you should come back with 6 variances, and we will evaluate it as compared to the existing building and the new proposal, not to something that they have never built. I find it very difficult to jump to, because at that time it's a package. We consider 6 variances, and then we...
In accordance with the plans submitted.
Exactly. And then now, the misleading thing is this, it's only, look like it's only 1 variance, which is not true. I think it still have 6 variances for the new proposal to the existing, what is there now.
With a different design,
Yeah,
right?
with a
I think
different
that's the struggle that I have, is I can't reconcile this design relative to what we approved previously.
All right, let's go on to
Can we
the next
speak to the
speaker.
staff?
Pardon?
So, is it possible to speak to the staff in a meeting and say, legally speaking, do we have that right to ask the zoning examiner to look at the variances again? Because legally speaking, those variances have been approved, and it is tied to the title, if I understand the legal process correctly. So do we, as a committee member, do we have the power to request the zoning examiner to re-examine the variances from a previous standpoint?
Through you, Mr. Chair, the applicant has submitted a waiver form. So if you want to defer the application in order for the applicant to obtain a zoning review, then you can take that option. That way the review is done by city staff. But in this situation, the applicant has submitted a waiver.
No wonder.
That's
Understood.
a good point, yeah.
But
Yeah.
it sounds like we're not comparing apples
Yeah.
to apples
Be-
because the plans are very different.
Yeah, exactly. The approval is really based on the previous design, which has got everything presented, and then to compare.
So let us finish our process and
Yes.
let Mr. Peterson speak to some of our concerns, and then we can make a decision. Elizabeth Kapusta.
I submitted presentation, so there are a few things.
Can we have your name and address first?
I am Elizabeth Kapusta, and I live at 429 Parkside Drive, which includes 4 apartments, 7, 9, 11, and 429 Parkside.
Okay, go ahead.
I think the crux of the matter here is that the rear addition is very different from what was previously submitted, and it makes a large extension into what's an essentially ravine area. And the height difference, which was originally kind of grandfathered in under the other application, now turns a relatively modest 2-story addition at the back into an almost 4-story addition because of the change in grade from front of the property to the back of the property. One of my objections is that the additional floor area variance results in a very out of scale, excessively large single-family home. Typically, 2.5-story is what's approved in zoning. This amounts to a 60% increase in the overall floor area to what's a 417 meters squared house, and an increase, a 72% increase in the footprint, which extends into a ravine in the back. Again, I would say this is more of a matter for zoning than it is for committee of adjustment, because 72% increase is pretty dramatic. The increase in floor area is going to have a significant impact in the landscape and which will affect my property and other adjacent properties. Affect the way rainwater drains, and it would also destroy a protected neighbor tree, which is misidentified on the arborist report. I would just also like to speak to a point of process that the owner did not approach me as the most adjacent neighbor or the neighbor on the other side on Indian Valley Crescent as a matter of courtesy to discuss any of these changes, nor did they approach any of my tenants.
So I think when you started out, you said this is a very different project than was approved. Is that correct?
It's extremely different because there's a very, very large projecting rear 4-story addition that is, the height of the addition is kind of amplified by the fact that the ravine goes down at the back of the property.
All right, so this is more impactful on you and Mr. Alakakos than the previous design.
Exactly.
Okay, thank you. Do you have anything further? You still have a couple of minutes.
I have a few administrative issues that the accuracy of the survey is not correct, which would also work in favor, which would impact my property. Just to make a point about also process, they've said that the property is not subjected to ravine bylaws on their application, but it is. And I would really appreciate the resubmission of that arborist report to correct the misinformation that it now contains. So to summarize, then the 4-story addition at the back of this property is very out of keeping with the typical 2.5-story character. The extension of the footprint back into a ravine protected area has a major impact on both the grading and the ability to protect those trees. So my tree is kind of slated for removal because it's been mistakenly identified as being on the subject property, but that's actually not the case. So with regard to that, I would ask that the front extension of the building be reconsidered. The 3-story volume extending about 10 meters past adjacent houses is very much out of context with the way typical houses in the area. I mean, there's probably room for something of an addition at the back, but it basically means that adjacent properties are in a kind of a light tunnel that is created by the rear extension, which is essentially a garage. Like, it's bringing garages into the ravine.
All right, thank you, Ms. Kapusta. Mr. Peterson?
Hi, thank you for the chance to rebut. There were several things said. I would say, first off, I had spoken to zoning, and part of my conversation with zoning around this was that the previous approval work was not tied to plans. You can look at the decision that's from the previous variances to confirm that they were not tied to plans. So the advice that I was given from zoning was that I was only requiring one variance because that was where I was wanting to change. Of course, it's for the committee to decide whether that the new form warrants the previous variances. But I would say a few things about this. One is that we have 5 letters of support that are from within the context of the proposal that believe that the building is within the kind of character of the neighborhood. Forestry has spoken. We've met with Forestry from Ravine and Natural Features Protection. I met with them last week, and they had no concerns at the time. But you can see from them that they have no conditions related to no comments offered as a part of their submission to the committee. We have a mitigating strategy so that there is only injury to the neighboring trees and with the likelihood that those trees continue to survive. And truth of it being that in old neighborhoods, there are these adjacencies of old trees that we are taking several kind of pains to kind of make sure that we are mitigating. And if we go back to the plans, and I'll speak to the other concerns, the west elevation, please. So yes, there. So part of what was discussed was that the loss of privacy. And you can see both in the plans and in these drawings that we've got mitigating measures for managing views east and west of neighboring properties so that the views kind of continue to look toward the backyards. The previous proposal also included, or the previous approval also included platforms. We're not seeking a variance for platforms because platforms above a certain height were already approved. And we're continuing to seek that. Part of what you see as well is that the building has balconies, but those balconies and the kind of total massing of the building is not one continuous wall as the approved variances would allow. We're really looking to stagger the building. It steps in several ways, both front and toward the back. Part of what we're trying to accomplish here with the building that steps this way is that the ground floor, we go to the next section of 400. Drawing 400. Thank you. Part of what the existing condition has right now is that you arrive on the ground floor and the garage is at grade and the ground floor sits well above that. So the existing condition has a large patio that is presently there. So to give them access to their backyard, we're stepping the building down towards the back by moving the family room down one level and then the platform outside patio as that kind of another intermediate level as it kind of steps towards the landscape in the backyard, rather than having one large flight of steps that's 8 feet high from ground floor down to the grade at the back, which made the backyard difficult to use. So this as a strategy becomes far more easy for access. And there's a lot of planting that we're proposing to continue the kind of green landscape toward the back. And in that sense too, I think it's misrepresented. The building is 3 stories tall, not 4 stories. And if we look at the rear elevation, we can see that the grade and also the that we see that the buildings, that 3rd floor is set from the face of that wall
25 seconds, sir.
So we're making, as the bylaw would say, a 3-story building. And the grade towards the back is managed by stepping the grade as well. Thank you.
Thank you. Okay, committee, we have comments? Larry?
Yeah, I'll start. I find myself at a bit of a disadvantage to consider this application because I'm having difficulty reconciling this proposal against what was originally approved and the variances that we approved at that time. I take the applicant's view or point that we didn't tie it to plans, but frankly, in this case, we probably didn't think we needed to. The proposal is substantially changed, and I think I would benefit from seeing it in its entirety. And if it benefits from having reviewing the waiver, having the zone examiner review this again, and I'd like to see it come back with all the variances that they're requesting against the proposed design that they're proposing. I'm not weighing in whether it's a good or bad design. It may be good, but I'm at a disadvantage because I'm struggling to figure out what we approved before, what the context of that approval was relative to what they're asking for now, which is an increase over what we approved and sounds like a fairly significant redesign. So I'd like, my view is that, I'll put it on, I think we should defer this and have it reviewed again and come back as a comprehensive package.
I agree totally because if I have to vote for this, I do not think this is minor. Anyway, asking for 14% of increase in GFA because if it was asked that figure before, in combination of asking extra height and extra length, our depth is over 6 meters, and the height of the wall is over 4 meters. In that context, if you're asking for such a large FSI, maybe at that time was not being approved anyway. It might be, you might have a chance got turned down. So when they come back with only just one variance, I think it's a little bit misleading. It's just not the same picture at all. So I hope that this will come back with a complete package.
Aaron?
Yeah, I'll just speak in a more pragmatic way that in case, I trust it's more like some advice to the applicant, I think. Not that we don't trust you, but we're just incapable to evaluate your project based on information in front of us, and that's why we recommend you to defer it. And if you get a zoning notice with only one variance, I guess you might want to present your case and comparing to what have been approved in your presentation file, which will help the next, which very likely to be us as well, to evaluate your project at the next hearing. Or you might just decide not to increase the FSI, and you don't even need to come back to see us, if that's the case, if what you said is correct. So that's basically my comment.
Yeah, I'm concerned about the process. I'm not sure what, and maybe Sabrina, you can help us with this. What happens with a zoning review? How's that going to affect what comes before us? Because what's coming before us is a completely different thing that came before the last. Completely different application than the last application.
Mm-hmm. So the applicant would submit an application for a review with the plans that we have before us, if that's the proposal that they want to move forward with. The zoning examiner will review those plans and then provide a list of variances that are required. And then the applicant submits that to the Committee of Adjustment staff, and we send out a revised notice with that list of variances.
So we make
It may
them-
be the same thing that we have now before us, or it may be more, right? Yeah.
So because the plans were not to be attached and followed, but the variances were approved at certain heights and depths and lengths, et cetera, the zoning examiner may come back, as you said, with the,
Well, the zoning examiner is going to review the plans that are submitted to them. So if it's the same plans that we have before us today, that is what the review is based on.
so, but won't they take into account the fact that there's been a
They will
previous
look at the
decision?
previous Committee of Adjustment decision, yes. But their review is based on the plans that are submitted to them.
So it may come back with just the same one
Exactly.
variance, right?
Exactly. Exactly. If the applicant is, what he said was correct, then he might come back with a zoning notice of one variance. And that's what I recommend the applicant, if he's coming back again, to show us a comparison so that it can help us to evaluate. Or he just decided not to increase the FSI, then he doesn't have to see us anymore.
I think Aaron's got a really good suggestion. I mean, I think Mr. Peterson would be very well advised to, if he has to come back, if we defer and he comes back, he'd be very well advised to write a cover letter and show the panel, you know, what was proposed originally and what is being proposed, that he got approval of the variances for, and what he's proposing today. And then at least the committee, whoever's hearing it at that time, will have better information than we have.
I still have a question, though, because his argument is that because the previous decision was made not tied to any drawings. He said that's why he could change, and then he just will stay with the variances, and that's only one. So I was told repeatedly before that if we do not tie to the plan, unless we want to tie to specific plan, like site plan or roof plan sometimes. But if we do not say that, it's still tied to the drawings. But otherwise, almost every decision we make now, from now on, we have to specify that these are tied to all the drawings submitted, right?
That's what I was told.
Otherwise, they can go and change them.
Yeah.
Well,
Yes.
through you, Mr. Chair, typically it's substantially in accordance with.
Yeah.
So even if there isn't a condition, the zoning or buildings division will look at the plans and ensure that they're substantially in accordance with.
So that's why you're saying the
approval.
zoning review may.
What I'm
change
saying
the
is that
variances.
we may receive the same variance that's before us today, or we may receive a different list.
Yeah, or we could refuse the application today because it has an adverse impact on the neighbors. Now, Mr. Peterson, I think, was a little disingenuous when he said, you know, we have no objections from people in this area, that area, but the two most affected people are the adjoining neighbors, and those are the people that are objecting to it. So I'm concerned about the process and how we should handle it, whether we should reject it or defer it and have it sent to a zoning review.
If you reject it, then he will just have to reduce the size of the FSI
Yeah.
and work with what have been approved and still move on.
So
If I
maybe
were
it's,
him to do that.
you think it's better to send it for a zoning review?
I think it's better to send it to a zoning review. Well, let's put it this way. He will have to go back to file the building permit. And at that time, based on my experience, all of the clerk will pass the information, the drawings to the zoning examiner to double check if the drawings are still meeting to the drawings that have been approved. And if that zoning examiner have determined that the changes have been significantly different than what has been approved, then he has the right to send him a new zoning notice. And then he has to come back again.
Which could be accomplished just by deferring it and
Exactly.
seeking a zoning review. That may be our
Yeah,
best
that's
course of
correct.
action.
Yes.
That's correct. So if we want to be nice, we can ask him to do that now by deferring it, or just based on the evidence in front of us, refuse it, right? But the question is, we have already shown, I mean, legally speaking or logically speaking, we cannot refuse it because we don't understand it. How can we refuse it if we have already claimed that we don't understand it, right? So I would lean towards to say that we would like to defer it and give the applicant an opportunity to ask for a proper zoning notice. And then so that we have enough evidence to evaluate. And then the neighbor, sorry, again, you have to come back by that time. And perhaps the applicant we should also encourage the applicant to speak to these two neighbors, right? Maybe there will be some new design and it was only notice. I think that would probably be the best for everyone.
So is your advice to defer it for a zoning review?
Yeah, now that he knows these two neighbors are very, very concerned about this design, so he should spend time with them, plus get a proper zoning notice. And if the zoning notice shows the same, please prepare a cover letter or a comparison chart so that we know what has been approved last time is being carried forward to here so that we can have a better picture to understand it.
Okay, so Aaron, make that just summarize that for a motion. Make the motion.
Okay. So I will make a motion to defer this application. What I have just mentioned is to encourage the applicant to actively engage with the two neighbors shown today to come up with a solution and to not to use the waiver, but to get a proper zoning notice with the zoning examiner. It's also good for you to move forward too, because what if you apply for the building permit and he said, no, you cannot do it, right? You have to come back to us anyway. So let's get a zoning notice, please. And if the zoning notice shows the same information as of you today, please prepare a comparison chart showing what has been approved and how you have been incorporating those approved variances into the new design.
Okay,
That's my motion.
so Aaron, I just want to be sure that you're not leaving it within the discretion of the applicant to refer it to a zoning review. I think we should refer it for a zoning review.
Yeah, we should say we request a zoning review with the current design.
Good, the current design, correct, yes, please.
Yeah, okay. So Sabrina, do you have enough information? Okay. Do we have a seconder?
Okay, I can.
Yim, all in favor? Thank you. The matter is deferred.
Thanks for coming down.
Thank you. Now, Sabrina, number 34, the speakers, et cetera, are crossed out in green. I don't know what that means on the speakers list.
I'm just going to look to John to see if we have Lisa or Emma. I think it was just one or the other. They didn't know who would be speaking. So we have Emma West online, so she'll be speaking.
What's her name?
Emma West.
Emma West.
Yes.
Okay. All right. So I'm not there yet, but I didn't know what it meant. Okay, next item is number 34, 70 St. George Street. The purpose of the application is to alter the existing building by constructing a three-story addition above the one-story portion of the building. With this application, we have material submitted by the applicant. We have email correspondence from Community Planning and a staff report from Tree Protection and Plan Review. Okay, now we have Emma West.
Hello, this is Emma West from 3 Church Street, Toronto.
Okay.
Do you require a presentation?
I don't think so. Looks reasonably straightforward. Do you have anything you want to say to the committee, to the panel before we go into committee?
Yes, if I could make a few brief remarks. I'm Emma West. I'm a partner at Fields, and we are the planning consultants for the University of Toronto for their property at 70 St. George. And we wish to thank you for your consideration of this matter almost this evening now, I guess. It's an important project for the university, and it aligns with their goals and vision, as well as the city's goals and visions for the university. It will introduce more classroom space, research spaces, and house a new innovative research group. There's a site plan application being reviewed by the city, and this minor variance application is the next step in the process for this important University of Toronto project. So I'm here to answer any questions, and you have submission materials before you that include the planning justification, summary in the form of a presentation, as well as some other documents. We note that planning staff have indicated that they have no comments or concerns, and I'll also note that our client, the university, is satisfied with the conditions from urban forestry.
Yes, what's this building going to be used for? Classes or what, or labs or what?
Yes, so it's the Lash Miller Chemical Laboratories building. That's the existing building, which includes a 1-story element, a 4-story element, and a 6-story element. The addition will be located on top of the 1-story element, so adding 3 floors to that. And it will be used for classrooms, research spaces, and a research group will be located in there as well.
Okay, thank you. Panel, any questions? Okay, do we have a motion? Aaron?
Well, let Larry go ahead.
Okay, Larry?
Oh, sorry. Sure. I think this is a very straightforward application. This is a good thing for U of T, a good thing for the students, and planning staff have supported it. There is no negative impact on the surrounding area, and it's in conjunction with other facilities on the site. So I think it's a straightforward application. I'll move approval subject to forestry condition number 2.
All right, you second that, Jim? All in favor? You have your approval. Thank you. I need
Thank you
some
very
more-
much.
Thank you. I need some help. I have to get to my next set of.
John, you have to teach him how to do
Go out
it.
of here.
Can I have 1 minute break? 1 minute. Okay.
That's it, I think. I think so. There it is. Yeah, it goes to 30, maybe 8 or something.
Hi.
Hocus pocus. Oh, wait a minute, I lost it. Yeah, but sometimes, every time I move to a new one, it goes smaller. I can't read it. Okay. Yeah. Okay.
Hey, Mr. Chair, I
Yes.
just want to let you know that I have to leave at 6:45. My wife can't come back home on time, so I have to pick up the shift to take care of my kids. So 6:45, I have to leave.
Okay. I hope,
Thank you.
well,
Just in case. Yeah.
oh, wait a minute.
No pressure. 4 cases.
We're at the wrong
45
spot. We're at the, did the wrong one. I was going to say we only have a few left, but we're supposed to go to 35. This is one we just
35?
did.
Yep.
So I don't know which one it is. Maybe it's the middle one.
That says 24 to.
Maybe I only,
28.
this,
Give me 2 seconds.
Okay. 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 Yeah. All kinds of little adjustments.
Last one.
Oh, yeah. Okay, thank you. All right, number 35, 2 Tecumseth Street. This is to obtain consent to sever the property into 2 lots. Lots to be conveyed are parts 6, 7, and 8, and address to be assigned. There's a lot frontage of 7.313 meters from Wellington Street West in an area of 4.922.1 square meters. Easements and right-of-way, parts 6 and 7 are subject to existing easements, rights of way as cited under instrument number CT 761388 and WF 47760E, and are going to retain parts 1, 2, 3, 4, and 5. Addresses to be assigned, parts 1, 2, 3, 4, and 5 have a lot frontage of 75.297 meters from Tecumseth Street in an area of 14.99.6 square meters. Easements and rights-of-way, parts 2, 3, 4, and 5 are subject to an existing easement rights-of-way as cited under instruments number CT 761388 and WF 47760E. Okay, with this application, we have material submitted by the applicant. We have email correspondence from Transportation Engineering. We have staff reports from engineering and a project analyst from Metrolinx. Okay, so Sean McGaffey.
Hi, good evening. How are you? I'm Sean McGaffey, Senior Associate of Urban Design at W&D Associates, 90 Eglinton Avenue East, Toronto, Ontario, M4P 2Y3.
Okay, so perhaps you could just explain to us exactly what's happening here. I have a view of this from my den and breakfast room window, and I'm curious as to what's going on exactly.
Sure, I'd be happy to. I've been the planner retained by TAS here for approximately 7 years now on this property. It's gone through a comprehensive official plan amendment and rezoning application, which was approved back in 2020. And that permitted 3 buildings on the property that's subject to this application. Permitted a 24-story building fronting Tecumseth Street, a 30-story tower sort of centrally located within the site, and then a 6 to 7-story non-residential building located behind the existing city works yard. And if you pull up the colored art plan that was submitted, that non-residential building is located within the pink area there, whereas the 2 mixed-use buildings are located within that green area. So since the time of the approval of the OPA and rezoning applications, CAS has also been selected as the proponent for the Wellington incinerator project. And as part of this, this application is really dealing with severing off the non-residential building and the mixed-use area. And the pink area will also contain the future 1,400 square meter addition to Stanley Park, which is located just to the west there. So there's a number of existing easements, as you noted in your opening statements there. Those are all going to be maintained. There are quite large trunk sewers that run beneath this property associated with the former Garrison Creek before it was buried, as well as a number of right-of-ways in favor of the lands across City of Toronto lands for access. So this is really just to create 2 independent parcels to allow for the development application to proceed through the site planning process as 2 independent pieces.
So that green area, that green area beside the blue area there, yes, so that's still Stanley Park, that part south of Wellesley? South of Wellington, I mean?
Sorry, this application is just located to the east of Stanley Park. So the main area of Stanley Park is on the north side of Wellington there, and then you have the off-leash dog park right alongside the north side of Wellington.
Yes.
Then the south side, you have that newer area with the Garrison Crossing.
Yeah.
So if you could look here on the part 8, what we call sort of the hockey stick, that hockey stick is ultimately what's going to be severed off in part to add to the existing Stanley Park and Garrison Crossing. And then the West Toronto rail path will extend across the southern portion of the site here. So as I mentioned, it's primarily related to servicing and access for the development to proceed. And, I'm happy to undertake those ECS conditions that have been proposed, as well as the Metrolinx matters that are being dealt with through the site planning application.
Yep, okay. I understand it better now. Okay, do you have any questions, panel? Yes, Yim?
I don't have any question. I just assume that because there's some comments from fire services and also the engineering community services, I just assume that eventually you will work those out with them, right?
Yeah, that's correct.
Yeah.
These conditions are really just to allow for, or to ensure that the consent is tied to what's going on with the site planning in terms of access and circulation.
Yeah, I think you still have to satisfy them. That's what we can tie.
Yeah, that's correct.
Make it as condition. I have no.
Okay.
Yeah, I'd like to move a motion to allow the servants with the condition that they will satisfy to the satisfactions of fire services and also engineering committee services, and the staff development engineering conditions.
You got Metrolinx?
Oh, Metrolinx also requests something.
Yeah, they have conditions.
Yeah, for that.
Through you, Mr. Chair, just a question. The Metrolinx conditions, were they done through the site plan agreement?
Yeah, sorry, maybe I can just explain that. So there's
So let's
two
come out of committee, and then we can.
Yeah.
Okay, thank you.
Go ahead, sir.
Sorry, so Ms. Chan just touched on the fire services comments, but those were from a previous ECS staff report. So now that they have sorted out those access arrangements through where they're at site plan now. There should be a July 20th, 2023 staff report from ECS, and it has three conditions in it from ECS that are appropriate in this context. And then the Metrolink matters are, from my understanding, dealt with through the site planning, which they've noted in their comments there. And those warning clauses will be secured as part of the site planning consideration. The advisory comments in this memo here are really just a reiteration of what's being commented on through the site plan application.
Okay, and so it's covered by the, yeah, right.
Okay, and sorry, through you, Mr. Chair, we do have someone here registered to speak in interest, so if we could just get them on the line, they're virtual.
Okay, they're not. Okay.
Michael, you've been unmuted.
Thank you. I'm in one of the properties that's just attached on the north side there of this to Tecumseth in one of the townhouses. Just trying to understand better, how does this actual separation impact development, especially from a impact to our townhouses that are attached to the development?
Okay, Mr. McGaffey, can you help us? Do we still have Mr. McGaffey? Yeah.
Sorry, I just need to be unmuted. This application is really just changing the underlying lot boundary for the development itself. So there's no change to any of the previously approved massing or setbacks or relationship density, anything of that accordance. This is really just creating two parcels to allow essentially two ownerships of one of the non-residential component and one of the mixed-use component. But otherwise, the development stays exactly the same.
Okay, thank you. Do we have any questions, or do we have a motion?
I think my motion is still the same, way, except that the Metrolink is already covered by the, in the other report. So
Yeah. Okay. So do we have a seconder?
Or did you keep the fire stuff in there?
Yes,
or you
yes.
removed it?
No, I didn't move that. I said only the Metrolink because that is being covered by in the other report.
Okay.
Yeah. So.
Okay. Do we have a seconder? Aaron? Okay, Aaron seconded. All in favor? Have your approval. Thank you, sir. Number 36, 91 Morningside Avenue. Purpose of this application, alter the existing two-story detached dwelling by constructing a rear two-story addition, a third-story addition with a rear balcony, a rear ground floor deck, a front porch, and a front yard parking pad. With this application, we have material submitted by the applicant. We have a report from Ravine and Natural Features Protection. We have correspondence and interest from 28 to Forest Road, and opposition from 28 to Forest Road, and 93 Morningside Avenue. Yeah, Jay Smith.
Good evening, Mr. Chair. Jay Smith, agent for the application.
Your address, sir?
2814 Hollington Crescent.
Okay, you have opposition. We need you to make a presentation.
We were before you previously. The application was deferred to talk with neighbors. What we've found is that the vast majority of issues the neighbors have raised have more to do with the building portion of the project. They do, still have some concerns with the massing, but we did arrange a meeting with the architect, the engineer who will be on the project, as well as the owner, the two neighbors, to address or to talk about their concerns with the build. And of course, they're looking for some assurances that we can't do until we've even got the drawings completed. Since the original submission, we removed the overall height variance, so we're down from 7 variances to 5. We reduced the massing of the proposed rear addition by 0.3 meters in length as well as 0.3 meters in width, and pulled away from the neighbor at 89 to give some more space for the footings and to, lessen any impact. The third floor was moved back 0.6 meters from the front to, again, lessen the massing. We have privacy screens, 1.5 meter opaque privacy screens on the third floor balcony, as is standard for committee. And the FSI has been reduced due to the reduction in massing. The other thing to note for the FSI is it's listed at 0.92. That is for the area that is allowed because of the TRC long-term stable top of slope, which is 209.8 meters. The lot is 275.3 square meters. So when you take the entire lot into consideration, the FSI is actually 0.70. So given that, and no objections by city staff, TRCA, I believe that what we're asking for is minor in nature. Thank you.
Okay, thank you. Any questions, panel? Okay. Yuen Yi?
Yuen, you've been unmuted.
Hi, I'm here.
Okay, can we have your name and address, please?
Yue Yi, 93 Morningside Avenue.
Okay, can we have your comments?
So, I'm the owner of 93 Morningside Avenue, the immediate neighbor of 91 Morningside Avenue. I attended the hearing on February 8, 2023, and that was deferred. I was looking forward to the applicant to discuss the revised plan, but until the new application was published in city's website, then actually we didn't hear anything before that. Means we have not given any consent. So my major concerns are below 3. One is the third story, like third floor. Once it's built, it will be my backyard. All of the sunlight will be blocked. And also that third floor with the balcony will be invading my privacy. So this is one of the main concerns I am having. Another thing is 93 and 91, we are sharing the mutual driveway. And in the Zoom meeting we had in August, I was asking, like, for example, how the applicant or the constructor will be make sure the safety of the mutual driveway, but no clear answer. And how to ensure the existing driveway will not be broken, and no clear answer. And also they mentioned they will need to use the mutual driveway every day, but with no clear plan and also advance notice. But I'm having 2 kids. Every day we run away from the mutual driveway. The safety concern is really one of my main concern. And another thing is through the drawing plan, for the initial plan, there are 7 variants. Right now, it animated to 2. Then right now there are 5 variances. But I compared and reviewed the 5 variants versus the previous version. But I don't think the revised plan is addressing any concern I am having. So first of all, the backyard, balcony, and the third floor. So this will be my windows. All my windows of my house is exposed to that balcony. So this balcony really needs to be eliminated. Then for the variance item 2, it's saying like that adjacent building, like all shadow study haven't. So in that cover letter of the 91 Morningside, there is no shadow study showing. But from that construction plan, I'm sure those will be block my backyard sunlight. And in terms of that FSI, I think it's that 50% more than permitted. So it's not a minor, it's significant variance. And for the mutual driveway, as I mentioned, like no clear plan how to make sure the safety, the road safety, and also no study for that because they are going to do underpin their basement. So there is no plan or no report to showing how the massiving and also the construction to make sure the adjacent building like my house and also 89 like how the safety. And there is a enroachment of that front porch stairs. So that one will be is also a 50% because it enroach some of the mutual driveway. So I haven't give any consent of that. So this is my concerns of those regarding this plan. So I'm sincerely asking the committee of adjustment could like maybe the constructor and the applicant could do a revision to make sure, or maybe have some reporting showing how to make sure those safety concern and with that sunlight shadow study and with that underpin basement safety, how to make sure all the construction is under the safe. Because right now we don't say anything. In addition to that, I want to mention that there is
you have 30 seconds.
Yes, I will wrap up. So in the survey, the 91 Morningside shed room is built on my property. So I didn't give any consent to the use of my property. Thank you.
Thank you. Any questions?
Just a quick question, Chair. Did you, I thought I heard when early on when you were speaking, you said that the applicant hadn't spoken with you. Have you had any discussions with them?
So before that I think I saw that application with the revised plan in August the 1st. So before that, we didn't hear anything. So it almost like 7 months because the first hearing was February and.
Sorry, I'm not being clear. I just want to know whether you've had any discussions with the applicant or not about their proposal.
Before August, we don't.
No, it doesn't matter. Like, have you had any at any time?
You mean after August?
Before today?
Before today, there was a Zoom meeting, but the majority regarding the 89 Morningside Avenue, I think James will speak later regarding his concern.
So there was a Zoom meeting. There was a Zoom meeting that you participated in.
Yes,
okay.
I participated.
Thank you.
Yeah.
Thank you.
Thank
James Schaus.
James Schaus, resident of 28 DeForest Road and owner of 89 Morningside Ave, where my 88-year-old mother lives. I have submitted a revised letter of objection based on the applicant's resubmission with referenced emails, photos, and drawings. In the event, I would like to ask committee, in the event that this application is approved, I would ask that the planning department makes provisions for the following, if this is possible. Although the building permit process is not public, I request the Toronto Building Department to make the builder's plan, in particular their underpinning design and methodology, available. So I may have it reviewed by a third-party structural engineer.
Sir, that isn't part of our mandate. We can't make those conditions. We're only dealing with the variances from bylaws, zoning bylaws.
Okay, so there's no stipulations on engagement as far as conducting a safe construction that I can ask the...
Well, that you deal with the building department.
And how, I've been told that I'm not part of the building permit process, so how would I engage them?
I'm not sure.
Through you, Mr. Chair. No, you're not part of the building permit process, but if you have questions, then you can reach out to the inspector.
Okay, excellent. Thank you very much for that information. I will act on that. Okay, so just to be clear, I did submit a letter and there are photographs as to the position of 89 and 91 Morningside. They're very close together. They're 45 centimeters apart, a foot and a half apart. So this construction is going to impact 89 Morningside. The massing is considerable against the one-story building of 89 Morningside. There are a couple of inconsistencies in the documentation. The survey and the site plan do show 89 Morningside as a two-story building. It is a one-story building, so obviously the massing of a three-story building against a one-story building is significantly more than the massing of a three-story building against a two-story building. The other thing I would like to input, and it's a little bit more technical in nature, that 100 years ago when they built one-story houses, the foundation walls would have been a certain thickness for a one-story, and they would have been twice that thickness for a two-story. So I want to make sure that there's no assumptions with regards to the strength of my foundation and slab because of that misinformation.
Sir, again, that is something you have to talk to the building department about.
Okay, so what I would like to note then is that information on the survey is incorrect.
Yeah.
There are a couple of errors in drawings with regards to the retaining walls too on the submission, but that is in my letter of objection, and there are photographs of that. Again, with regards to the four tests for minor variance, the FSI is about 153% of bylaw standard, and the sidewall height is about 118 of bylaw standard. So this along with the two-story rear addition does increase the amount of shading. And also these two-story, there are other detrimental aspects to the neighboring properties related to the two-floor rear addition, which would be access to the adjacent property for the purpose of maintenance and drainage and increased shading. So if you take a look at attachments 5, 6, or 7 on my letter of objection, you'll see the proximity of the two houses, and you'll get my intent with regards to rainwater shedding off of one building onto the other in between the houses and trying to keep that pathway clear so there are no foundational problems on either property. With regards to maintenance, you see, with regards to attachment 7, you'll see that the rear extension will actually fill in that space on the left of my old foundation wall on the right. The restricted access to the foundation walls of 89 Morningside due to the rear addition will impede general maintenance of the stone and mortar foundation. Again, it's over 100-year-old house, and it does have a maintenance requirements on that wall. So filling in that
25
space
seconds,
on the left
sir.
Okay. It's too big for the neighborhood, and I have construction and safety concerns and shading concerns. Thank you.
Thank you. Nicholas Singh.
Hello, can you hear me?
Yes.
Oh, great, thank you. Yes, Nicholas Singh, representing the Swansea Area Ratepayers Association and Group. I submitted a supplemental document. I believe it was late. You can have a look at that later and reference that. Focusing on the application, when this application was deferred, the association indicated its willingness to be part of the consultation. The developer did not reach out, instead attempted to negotiate directly with the neighbors. And the result, as you're aware, is that there is no agreement on the current proposal and very little change has been achieved. This is essentially the same building, the same issues. The biggest change is being in the height bylaws, but I stress that the building height at 9.8 meters has not changed, just the requirement for the variance. The other variances themselves have changed very little. The association supports the neighbors' concerns about the impacts of shadowing, massing, with reduced setbacks accentuating the problem, overlook, and loss of privacy. And we ask that you give their concerns full consideration. Address the claims that the developer has made in support of this application. The Sketchworks cover letter says that the variances are in keeping with previous decisions approved in the neighborhood. The developer has offered 5 examples for various approvals. Previously, at the other application, there were 6 examples, and at that time, the association's letter laid out why this approach was inadequate. For the current proposal, none of the dates of approval are given, so we don't know how old they are. We don't know how many were refused in the same period. We don't know how many were constructed without applying for any similar variances. What we do know is that 5 examples is very few. We know that if we accept the neighborhood that the applicant himself has chosen for comparisons, there are 62 properties. And we know that 5 out of 62 is 3.1%. We also know that when comparing similar variances to similar approvals, you will always have a 100% match. But when you realize that this is only 3% of the neighborhood, there's clearly a mismatch between the neighborhood and the 5 examples. Based on the data provided by the applicant, the variances for FSI and for height are only 3% match and do not support and reinforce the prevailing character of the neighborhood as required by 4.1.5 of the official plan. As there is no evidence before the committee to support the opinion that the applications for FSI and height maintain the intent and purpose of the official plan and zoning bylaws. In fact, the 3% match supports the opposite opinion that the FSI variances fail the test for the official plan and the zoning bylaws. And 3% is generous. There are actually only 4 out of 5 that match the applicant's requests. So the evidence provided by the neighbors for the immediate context is far more compelling, with 4 one-story homes within 2 addresses of 91 Morningside Avenue. And photos were provided by the neighbors. The applicant also claims that there are no variances for the building length, building height, or landscape area. And given that, the applicant believes that the requested variances are individually and cumulatively minor in nature and meet the 4 tests of the Planning Act. It does not follow that because there are no variances for building length, building height, or landscape area, that the requested variances are minor or meet the 4 tests. In the absence of one variance, the absence of one variance is not proof that another variance meets the 4 tests. In fact, each required variance must be shown to meet each of the 4 tests. Regarding the FSI and the TRCA, the argument that the FSI is artificially high because the TRCA requirements make it technical is correct. In fact, where measurements are required, they're all technical. This is an empty claim. The neighborhood is covered in hills and valleys, and each building must comply with the technical aspects of its geography. The requirements of the TRCA were put in place to manage the hazards associated with these properties on a case-by-case basis, and the requirements should not be discounted. This is a condition of many homes in the neighborhood, and there's no good reason why this one should be exempted. So the variance requested do not meet the 4 tests.
20 seconds, sir.
Thank you. Should the committee approve the application, however, we request the following condition to address the neighbors' concerns regarding damage. We recommend that the applicant be required to perform a pre-condition survey of the neighbors' homes and property that the neighbors will have access to should there be a claim of
Sir,
damage.
that has to do with building. That's not part of our mandate.
As you see it.
All right, your time is up.
That is the end of my presentation. Thank you.
Thank you. Mr. Smith.
Yes, Mr. Chair. I'll start with the items brought up by number 93 with respect to the front porch. There are no variances for setback for the front porch, and we are staying outside of the right-of-way. We're not encroaching into the shared driveway between the homes. The 3rd floor stops at the existing rear wall of the homes. So the 3rd floor will not be projecting past number 93's house and will not be projecting past number 89's house. So I understand the concern for shadow, but it's minor in nature, in my opinion, given that we're stopping in that position. The other thing is the 2-story rear addition that's proposed is over 2.2 meters setback from the lot line on number 93's side. So again, I'm not sure how the shadowing is going to affect the rear yard. We do have the privacy screens on the 3rd floor. If they would like to be increased to the 2-meter maximum height, that would be totally fine with us. Number 89, we have a 0.62 meter setback. We increased the setback of the addition by 0.3 meters just to help address drainage and foundations. There's enough room for us to get shoring in, remain entirely on the property, and not impact the neighbors' footings. According to Mr. Singh, it's 3%. The transition in the neighborhood is happening. There are a lot of new homes. I've shown the examples, all of them under 569/2013, that all show higher FSIs, higher wall heights and overall building heights, as well as setbacks compared to the one that we're proposing. So I do believe that it's minor in nature, and I do believe the neighborhood is transitioning. I'd be happy to answer any questions that the committee has.
Any questions? Okay. Do we have a motion? Larry?
Thanks, Chair. When looking at the 5 variances that are before us, I find that they are in aggregate quite minor. And it's good to see that the applicant, upon getting this deferred previously, has gone back and reduced the original variances. And in fact, probably the more significant one is reduced the height or eliminated the height variance, which I think is good. I would agree with the agent that this area is in fact undergoing transition. This street has got several new builds on it at the top of the hill. The surrounding neighborhood is subject to a lot of renovation and a lot of new builds. So it is in transition. I don't think this particular proposal is out of character at all with some of the developments in the neighborhood. I think the fact that the rear balcony terrace is screened is good and should address the overlook concerns from both sides. And again, I don't think it has the kind of negative impact on the adjacent neighbors and the surrounding neighborhood. So I'll move approval of this application, and there are no conditions. Maybe what we do, Chair, so that we get the screening in, we'll tie it to plans.
Yeah. Okay, you second the motion, Yim, all in favor? Have your approval, sir. Okay, Aaron.
Yeah.
Aaron. You're gonna leave
Going
now,
to say,
Aaron?
yes, please. I will see you next time, and thank you so much
Okay.
for taking care of the rest
All
of the
right.
night.
Thank you. Thanks for your
Thank you,
help.
staff as well, Sabrina and everyone. Thank you.
Thank you.
Thank you, Aaron.
All right, bye, Aaron. Okay, number 37, 132 Cardona Avenue. Purpose of the application to alter the existing one-story detached dwelling by constructing a complete second-story addition, south side and rear two-story additions with covered front and south side porches, a covered rear deck, and a rear basement walkout. Also, the existing ancillary building, detached garage, and the rear yard will be demolished. With this application, we have material submitted by the applicant and a report from Urban Forestry. Kelly Lim.
Kelly, you've
Lem,
been unmuted.
Good evening, Mr. Chair and members of the committee. My name is Kelly Lem. I am at 201 Wickseed Avenue, Unit 15, Toronto, Ontario.
Okay,
And I am the agent for the owners.
all right. So before we take it into committee, do you have anything you want to say to the panel?
Yes, I'd like to just give some background information. This project was deferred from a previous hearing in July 26, and that was just basically due to a technicality on variance number 10. We made a late change to eliminate forestry concerns, which was to reduce the, was to maintain the length of the parking pad, but entirely on the owner's property. And as well as we wanted to make the change to reduce the width of the parking. But because this was late and the original variance was for length and not changing the width, we had to defer the application. Furthermore, there was no comments from staff and as well as we had approval from 9 signed signatures, which included both adjacent neighbors on either side. And at that time, there was no presentation required, and there was no objections.
Okay. Any questions? Okay, we have a motion? Yim?
Okay, yes, yeah, I can make a motion for approval. I think the variances altogether, I think they're quite reasonable. They're nothing that really stand out for me. So with the forestry condition number 1, I will move for approval.
All right, you second that, Larry? All in favor? Have your approval, sir. Thank you.
Thank you very much, members of the committee.
All right, number 38, 52 Everett Crescent. Purpose of the application to permit the 2-story detached dwelling with a rear 2-story and a rear ground floor deck, which was constructed beyond the limits of the authorized building permit. With this application, we have material submitted by the applicant and 2 form letters in support. Joseph Dom?
Yes. My name is Joe Dome, 133 Torresdale Avenue, agent for the owner.
Okay. So is there anything you want to say before we go into committee?
Yes, I do have a short presentation. I would like to also offer some context, just that it was deferred previously just to confirm the correct lot coverage with the zoning examiner. And that the owners have received letters of support from both adjacent neighbors at number 50 and 54 Everett Crescent. Planning staff have no concerns with the application as well. The owners had received the building permit for the 2-story rear addition in 2019, and during construction, the west side wall of the addition was extended by 1 foot. So the indent was supposed to be 1 foot 6 inches, and now there's a 6-inch indent. The deck was also added to follow that same setback. However, the setback of the addition and the deck, 0.22 meters, is still greater than the setback of the existing dwelling, 0.14 meters. And the proposed lot coverage, 43%, is mitigated by the fact that the total dwelling length is only 11.84 meters and no overall height or main wall height variance is requested. And also, finally, the neighbors 2 and 3 houses to the west at number 58 and number 60 Everett Crescent have 2 full 2-story massings, even extending further to the rear than number 52, occupying a larger massing and lot coverage. And overall, we just feel this application is reasonable and minor in nature. I'd be happy to answer any further questions.
Any questions? No. Okay, you have a motion?
Oh, I can, yeah. All right. So, I think this is quite minor, and then they have the support of both neighbors. And this just to correct some of as-built conditions. So I move for approval with no conditions.
Second that, Larry. All in favor? You have your approval.
Thank you very much.
Thank you. That completes the agenda.
It's 7:45
p.m.
It's 6:45.
You can stay till 7:45, Larry.
Thank you, everyone.
Thank you.
Thanks, guys.